Hey, good morning. Hello, everyone online. Hello, everyone in the room. I just want to welcome everybody to this kickoff meeting. And on behalf of the Access to Justice Commission, I thank you so much for being willing to serve. My name is Lisa Hobbs. We're going to talk a little bit more about the leadership here in a second, but I'm joined with my friend Kenan Wooten and my friend Justice Michael Massengill. And we're kind of your leadership team, and we're sort of, winging this as we go along too. But I can't thank you enough for volunteering. We think this is just the most exceptional working group. You represent around this table and online, you represent different paths of our study of this very important issue. And we're just so grateful that you all agreed to serve on the meeting. I'm going to try to keep, because I think Justice Busby is, who I'll introduce in a second, is going to do more of the welcoming thing. I'm hearing voices. Is that just, am I still okay, Craig?
Good.
Okay. I want to say that the working group members all received an agenda and some materials. Those haven't been made available online, mostly because I just am still trying to figure out the technology of how to do this. But we will, when we post the recording of this video, we will make those materials available to everyone who is listening in today. And if you are listening in, we really appreciate that you've taken the time to watch the working group. Within the materials, just a refresher for everybody here and to those online, we gave a brief summary of sort of what's happening across the country related to this subject matter. And then we provided sort of articles. If we provided you every article that Justice Massengill and Ken and I have read, y'all would have been overwhelmed. But we tried to pick and choose some that we thought would just get you a flavor of what is happening around the world, around the country with regard to this. And also on behalf of the Access to Justice Commission, I just want to take a moment to thank the Texas Supreme Court for prioritizing this and asking us to study something that could really expand access to justice and our mission as a commission. So we're just delighted to be a part of this and thank the court for just always having the interest of low-income Texans and their ability to access the court system as such a priority. So thank you to the Supreme Court for allowing us to study this. Okay, just another housekeeping matter. How this is set up, unless Craig corrects me as I'm wrong, I can see working group members online, and I will eventually see and everybody in this room will be able to see our invited guests. I cannot see individuals who are just tapping in, and we're so glad you're here. And so there is a chat feature for the working group members. We expect like, hi, Lisa, we can't hear you at all. But I can't see it. So I think Trish and Craig can see it, but I can't see it. So just with your chats, we're going to be relying on just 2 people in this room who can see those. Also, those will be made part of the permanent record of this hearing. So just keep that in mind as you're chatting amongst yourselves for the participants. And just what we anticipate happening today is I am learning, Justice Busby is learning, we're all learning about what's going on in other states and just setting the tone for this. But today I will say is going to be mostly about listening. We all have so much to learn and we we have some invited guests that are just meant to educate us about that process. I am so thrilled that the commission was able to partner with the National Center for State Sports. And we have Katie Hennessy here today from the National Center. And we'll introduce her in more detail a little later. But they really helped us compile just the preliminary information, but most importantly, getting these great speakers so that we can know what's going on. So thank you, Katie. And we're so excited to be working with the National Center on this project. If you do have any, for those who are online and not part of the working group, please know that we do want to hear from you. And we have an email set up for you. And so if you have any suggestions about just generally the process as we're getting started here, or any other comments, the email address is suggestions@texasatj.org. So again, the email address for any input about our process is suggestions@texasatj.org. So we do want to hear from you and invite you to send us your suggestions as well. I think those are my very practical introductory remarks. So I'm going to turn it over to our esteemed leadership here. We have Justice Busby with us, who really does need no introduction, but I wanted, for those of you who don't know, he is our liaison to the commission. And so that is his role being here. And then I think right after Justice Busby, Harriet Myers, who is the chair of the Access to Justice Commission, also has some remarks to give us as we're getting started here. Justice Busby.
Great. Well, thank you, Lisa, and good morning, everyone. We greatly appreciate your willingness to join us in this working group. And just to kind of set the stage about what's the issue that we're addressing here, as I mentioned in the letter that I sent to the Access to Justice Commission, that we're really building off the work of the Texas Commission to expand civil legal services and the scope of the need that they identified. And as we were oversharing with the legislature just recently, here's basically the latest statistics on the scope of the issue. There are over 5 million Texans who qualify for civil legal aid because they barely make enough to provide for necessities. They certainly don't have enough additional resources to pay for a lawyer. And each year, we're able, legal aid organizations and volunteers, and through money that we're able to raise from the federal government, state appropriations as well, donations from lawyers, we're able to serve over 100,000 Texas families, but that's about 10% of the need. So there is a huge unmet need out there that we're not able to meet between federal and state dollars that fund legal aid, between pro bono services that our Texas Bar provides, and donations that lawyers around the state and others who hear about this issue are able to give. And that's not at all to minimize those efforts, because they're critical and they meet very important needs, but the scope of the problem is just multiple times greater than we are able to address on a yearly basis. And so having discussed this with the court, we think that this is an issue that needs to be addressed. It is something that we need to think more broadly about, something that we need to examine other solutions to be able to address this issue, because doing nothing is not an option. And so the Chief Justice, I wish he could be here today. He'll probably join us for our next meeting, because I want you all to hear from Chief Justice Hecht on this. He's been the president of the Council of Chief Justices and has worked with a lot of courts around the nation to figure out what are the best solutions that are coming up that other states are looking at to try to address this need, and it's specifically for low-income Texans, again, who can't afford traditional legal representation. And so this is something that he has helped talk to all of us on the board about and inspire us to ask you to come together and look specifically at two possible solutions. One is modifications to the rules that would allow qualified non-attorney paraprofessionals to provide limited legal services directly to low-income Texans. And then the second one is modifications that would allow non-attorneys to have economic interests in entities that provide legal services to low-income Texans while preserving professional independence. And these are solutions that, as you'll hear, are being tried in other states. I emphasize that the court has not made a final decision to adopt rules on these subjects. We want to hear from you all, and that's why we put this process together, because we want to get input from all parts of the bar and all parts of the legal services sector, people who are working with low-income Texans. We want to hear from not only the legal community, also the business community, also the public at large. What do people who are consumers of legal services as well as providers of legal services, how do they understand the scope of this problem, and what can we do to best close this justice gap that I mentioned at the beginning? And we want this to be a win-win solution. And based on what we have seen in some other states, we think that there is great potential to do that. For example, with non-attorney paraprofessionals, we've seen in some of the other states that are trying this, that lawyers have actually been able to expand their offerings and reach consumers who would not necessarily be able to afford a lawyer, but are able to, by expanding their offerings to include paraprofessionals, they can actually serve more people. So they're helping the consumers and they can increase their own bottom line at the same time. Similarly, on the non-lawyer investment in law firms, some of the things that we're seeing in other states that you'll hear about include the use of technology and companies that are able to start with technology solutions. And then once the consumer comes in and answers some questions, they can be connected with a non-attorney paraprofessional or an attorney to answer specific questions that will help them get to the answer that they need and get their business done in the legal system so that they can resolve the issue that they have and get on with their business. And so again, that's for those people who participate in that process, that's been an additive because these are people who would not have had the funds to pay lawyers in a traditional model. But if you can, if it's easy for a lawyer to be connected to a client like that, and they're able to do that with many clients at the same time, you can actually, and the clients are, by the same token, having a more limited scope of services. And so they're able to, in some cases, pay something. In some cases, we're also able to, these other states are able to raise money for targeted resources to help those who can't afford to pay anything. But it ends up being a net additive to for the consumers because they're being served, for the lawyers and the non-attorney paraprofessionals who are involved. And so that's one of the things that we're hoping that you will help us investigate is how do we come up with a win-win solution that's good for everybody in this. And it seems like from what we're seeing in other states that that is possible. And we want to be sure, again, that we hear input from all sides of the issue, from legal consumers, legal providers, all folks who are interested in this process so that we can come up with rules that will help meet this great need and strengthen the profession in the process. So thank you very much for being part of this effort. We are very appreciative at the court of the time that you've agreed to give to this. And we think that it has the potential to be a good step forward for the state. There are a lot of issues that we'll need to go through to look at this. And I want to particularly thank our working group leaders, Lisa and Kenan and Michael, they've already put a tremendous amount of work into this and will continue to do so in being sure that we're collecting the input that we need to make this process successful. I want to thank Harriet Myers, the chair of the commission, whom you'll hear from next, who has been tireless at being sure that not only on this issue, but so many other issues that the commission addresses, that we're doing right by Texans who can't afford traditional legal services. And I want to thank Trish McAllister, the executive director of the commission, and her staff, who've been very helpful in getting this process set up. And I want to thank Katie Hennessy, who you'll be hearing from more later from the National Center for also organizational effort and knowledge that she brings to this project. So with that, I'm going to turn it over to Harriet Myers for further remarks, and look forward to being with you throughout this process. And if anybody has questions for me, either during the breaks or separately, I'll be sure to provide contact information for everybody. And I think it's on the information that was already distributed to folks. So don't hesitate to call or email me. My door's always open, and look forward to visiting with you all further about this process and our work together. So thank you.
And thank you, Justice Busby, and thanks to the Supreme Court for asking the commission to take on this task. We are grateful for that opportunity and appreciate having received the October 24th letter. I do, at the very beginning, ask every person who has an interest in these subjects to read carefully that letter as was described by Justice Busby, because it is very careful and very explicit in what is set out as to the tasks that the commission is undertaking. I thank our co-chairs. They are remarkable. Lisa, Kenan, and Michael are just chosen because of their leadership roles in our profession, the work that they've done previously in areas of rulemaking, in governance issues, serving as a justice of an appellate court in our state. These individuals are truly gifted, and we are so appreciative that they are lending their valuable time to this effort. And I want to always thank our partnerships with the State Bar. Trey Apple is here, Caitlin Lady is here, and just appreciate that relationship so much. And they've already been just tremendous help to us, and we know that will continue. We thank our staff, Trish McAllister and the others who contributed to setting up this meeting and getting us organized. And of course, we are extremely thrilled that the National Center for State Courts has stepped up to, particularly through Katie Hennessy, but others, I'm sure, to assist us in what will be a very time-consuming, very intricate analysis of a number of issues. I want to thank Laura Gibson and the volunteers that serve our bar. They are remarkable leaders for us, and I'm sure will be providing incredible input for us also. And I am also just want to say that and emphasize, because it was said very well by Justice Busby, we are not planning to just go look at a state and say, this is what Texas is going to do. We're going to do our own analysis, our own study, and our own determinations of what recommendations should be made. And in doing so, we want to be the best word, and I've heard it said by our co-chairs and by Justice Busby and everyone, we are going to have a transparent process here, inviting any and everyone who wants to comment, wants to help, wants to make sure that we have thought of everything we need to think about in this process to come forward and be with us and work with us through the avenues that we'll make available. The Access to Justice Commission will do, though, this in our Texas way. Texas is unique. Texas, our Supreme Court, our other courts, our bar association, this unified bar, our lawyers all have interest in this discussion that we will have, the study and the recommendation, and we will hear from everyone and be informed by all of the work that's been done in other states and how those might contribute to our process. We know, just say it up front, there are skeptics and could say already opponents. Our request to you is to come along this path with us. Let the work be done. Keep open minds. Keep contributing where you can contribute, and hopefully as much as is possible, we can all stay on the same page to accomplish what this is all about, which is providing legal services to the low-income Texans who direly need those services but are unable to get them. So please watch us closely, contribute where you can, and we welcome all of that. We, as has been said, have serious problems of lack of access to justice in our state. This commission was formed by the Supreme Court in 2001, and the state bars, the court, the local bar, the local bars, all kinds of nonprofits, specialty bars. Everyone is doing work to try and address these issues, but we have still the problem and it is a problem, a serious problem, as Justice Busby described. We have to explore what we can to relieve the hazards, hardships, and the waste when we leave our low-income Texans in a situation where they have no justice available to them. We will do our best to address and make progress in trying to make sure that our low-income Texans have the representation that they need, and that we contribute not just to their lives, and those lives are in jeopardy many times. Their income is in jeopardy, their homes are in jeopardy. All of these aspects of a reasonable life are denied to too many in our state. And that's why we're all here and why we are dedicated to making progress. And as we help them, we will help our society, because we will keep families in their homes. We will do things through the work of the commission, this effort and otherwise, if we're successful, to ensure we have contributing members of society rather than individuals whose lives have been ruined because of a lack of access to our justice system. Thank you, everyone, for being online, for being here to contribute, to listen, and we look forward to the work of the working group as well as all of us. And now I will, I think this is where we would like to be, have everyone introduce themselves so that we get a sense for who's involved in this process. And I know people will be brief and not do justice to the outstanding careers that we know they have. No one is leading this effort. No one is on the working group who isn't outstanding members of our profession. And so I'll turn it back to Lisa and we can start with introductions.
I think that is great. I also just want to let everybody know, I think I said it at the very beginning, but some of us may have joined, is we logistically cannot see hands being raised and things like that. So we're going to have a a period after lunch where we can have more commentary and things like that. But like I literally cannot see these things. So we'll, as like I said at the beginning, a lot of this meeting is about listening and learning, and we will have all the opportunity for public input further on along in the process. So I just want to apologize that I am not seeing you on the screen. I'm Lisa Hobbs. I've already said that. I am a commissioner of the Access to Justice Commission. I get tapped for these fun projects because I was the former general counsel for the Texas Supreme Court way back in my 30s. And I am an appellate lawyer here in town, focusing almost exclusively on appeals, and dedicated to access to justice, and so happy to be a part of this group, and the record that we are creating for the court on this important issue. Kenan.
Hi, everyone. I'm Kenan Wooten, and I'm a former rules attorney for the Supreme Court of Texas. I also served on the Commission to Expand Civil Legal Services, sometimes referred to in shorthand as the Justice Gap Commission. I became really interested and dedicated to increasing access to justice when I was a clerk at the Supreme Court of Texas, serving under Wallace v. Jefferson, and hearing about all the need and all of the effort. I am currently on the State Bar Board of Directors. So fortunately, with the collaboration we have ongoing, we have several avenues for communication between the work we're doing and the work that the board is doing. So hope I can help with those efforts. I'm also an attorney here in Austin. I do primarily civil litigation work, general civil litigation work, and also some appellate work. I just want to say I'm so excited about working with all of you, serving with all of you. Thank you very much.
I'm Trish McAllister. I'm the Executive Director of the Texas Access to Justice Commission. Keep it short and sweet.
Robert Doggett, Texas Rio Grande Legal Aid.
Linda Acevedo, I was a former Chief Disciplinary Counsel for several years, and hopefully I can help if we get to the regulatory portion.
Good morning. My name is Monica Caratori, and I'm the General Counsel at CenterPoint, soon to be the Chair of the HBF, and a former Commissioner. So it's great to be among friends again.
Great. Good morning, everybody. My name is Joe Cleveland. I'm the chair of the intellectual property section of the State Bar of Texas. And we've been running a pro bono program for the last 5 years. Happy to help be here as an invited guest. Thank you.
Good morning. I'm Mary Spector. I'm the Associate Dean for Clinics at SMU in Dallas. I also run our Civil and Consumer Clinic, where I supervise students representing clients in evictions and debt defense.
I'm Laura Livingston. I'm a recently retired civil district judge here in Travis County. I'm a former legal aid lawyer. I'll soon be the state delegate from the state of Texas to the American Bar Association's House of Delegates. And so lots of different hats, hope to provide different perspectives.
Hi, I'm Ellen Lockwood. I'm a paralegal. There, I said it. I'm in San Antonio. I do intellectual property, primarily trademarks and copyrights, and I work for a firm that's actually based out of Minneapolis. And I will just say this weather is nice compared to when I left Minneapolis yesterday. I am a past president of the paralegal division at the State Bar of Texas, but the reason I was asked to join is because I am quite involved in paralegal ethics. I do a lot of speaking on paralegal ethics, a lot of writing on paralegal ethics, and so I'm looking forward to being involved in helping us navigate that ethics issue from a paralegal perspective.
I'm Paul Furr. I'm the Executive Director for Lone Star Legal Aid. There is one point I'd like to make. This is the third committee that I've served on that's looked into this issue, and may be worthwhile to go back and look at some of those.
Good morning, I'm Trey Apfel. I'm the Executive Director with the State Bar. Prior to that, was practicing trial attorney for 35 years. So.
Chris Ritter, I'm legal counsel here at the bar, and I've been very involved with the TLAP program in the past, and before that was a trial lawyer in Lubbock.
Hi, I'm Katie Fillmore. I'm an ATJ commissioner, and I'm on the board of Texas Young Lawyers Association. The young lawyers are very interested in this issue. I update them on ATJ things at each of our meetings. So I hope to be a voice for young lawyers who are oftentimes in the trenches with paralegals, and I think can offer a unique perspective.
Hi, I'm Richard Lavallo. I'm legal director at Disability Rights Texas.
I'm Craig Hopper. I'm an Austin attorney in trust and estates and probate. I'm the immediate past chair of the real estate probate and trust law section of the state bar. But kind of key to this group is that for about the last 6 years, I've been on another Supreme Court task force to create simple will forms and simple probate forms, along with our chair, Judge Polly Jackson Spencer, and with Trish. So it's a pleasure to be here.
Good morning. My name is Sid Harrell. I was on the bench in San Antonio for 30 years, 226 District Court, civil and criminal. I retired in 2008 and I was appointed by the governor to be the regional presiding judge for the 4th Administrative District, which goes from San Antonio down to Laredo, over to the coast, 22 counties. Pleasure to be here.
My name is Maria Thomas Jones, and I'm the executive director of Legal Aid of Northwest Texas. We're out of administrative offices in Fort Worth. I cover 114 counties, both rural and urban and suburban. We have a very robust pro bono program as well throughout our area, and so I'm happy to join the commission.
My name is Jonathan Bates. I'm a family lawyer from Dallas. I am the immediate past chair of the family law section, and that's the role that I'm representing today.
Excuse me. I'm Richard Melamed, a real estate practitioner from Houston. Was a section rep to the board formerly. The last few years I've been on the landlord tenant task force.
I'm Katie Hennessy from the National Center for State Courts, and you'll hear more about me in a little bit.
My name is Michael Massengale. I'm based in Houston, and I'm a former judge of the First Court of Appeals based in Houston. Very appreciative of the Supreme Court to have invited me to participate in some of its most important projects of judicial leadership, such as Children's Commission, which I served a couple terms on, and now have the great privilege of serving as a commissioner on the Access to Justice Commission and also on its executive committee. And I'm not sure how I got selected for this particular project since I never worked at the court, but I am deeply grateful for the opportunity to be part of this very important project, and I'm excited about the opportunity to work with all of you. The need is palpable, and the opportunity is in our grasp. So glad that we're finally at this stage and getting started. Do the people online?
We are, but I'm going to ask Kenan to do it because I cannot see any.
Other people in the room.
I've left my. Oh yeah, sorry. We do have some others in the room too. Thank you, Judge Livingston.
Hi, I'm Barry Martinez. I'm section rep for the immigration section.
I'm Kaylin Laney, one of the deputy executive directors of the state bar, and I'm just always together for a really long time.
I think it's only right to introduce Craig Chapman. He
Yes.
has been invaluable in making all of the technology work as it should today. All right, so online, for the people we can see, I'm just going to go in the order in which you appear to us in the room. So Judge Spencer, do you want to go first?
Sure. I'm Polly Spencer. I'm an allegedly retired probate judge from San Antonio. At least I am from San Antonio rather than Houston. And as Craig mentioned, I've been serving as the not terribly effective, perhaps, chair of the task force to produce probate forms, which we've been working on for 6 years, but it's been eye-opening, and we've all improved our grammar quite a bit while we've been working on that. Honored to be a part of this.
Judge Spencer, we definitely know you're from Bear County, and I apologize. That was a typo on my part, so I apologize for that.
Well, Judge Harrell communicated with me the other day asking if I had moved. So
they'll take you in Houston, Judge. They'll take you in Houston.
I was terrified I lost her as one of my visiting judges.
Thank you very much, Judge. Terry Tottenham.
Good morning, everybody. I'm Terry Tottenham. I'm a lawyer from Austin. Honored to serve with such a distinguished group.
I could say a lot more about Terry, but I'll leave it at his brief remarks. Susan Ford, professor.
Good morning. I'm a professor at Texas A&M Law School, and I focus on legal ethics and malpractice.
Thank you, Professor Fortney. Laura Gibson, president of the State Bar of Texas.
Hi, good morning. Thank you so much for being here and for the hard work you're going to put into this important issue. As Kenan says, I'm the current president of the State Bar of Texas, honored to be the 8th woman and the 142nd president of the State Bar. And as everyone has said, this is very important work, and I'm confident that with the brain power on this working group that we can find a solution that will help low-income Texans and also protect our lawyers' rights to earn a living with the education they've received. So thank you very much in advance.
Thank you, Laura. Daniel Hirsch, and please correct me if I mispronounced your last name.
No, it's perfect. Thank you. Hello, everyone. My name is Danielle. I work with Katie Hennessy at the National Center for State Courts. So thank you very much for the opportunity to be part of this project.
Thank you for your help. Cindy Tisdale, president-elect State Bar of Texas.
Yes, Cindy Tisdale. You just did it for me, Kenan. Cindy Tisdale. I'm a family law attorney in Granbury, and I'm president-elect of the State Bar of Texas. Thank you all for being here.
Thank you very much. Karen Miller.
I'm Karen Miller. I'm the Executive Director for Texas Legal Services Center, and we're a statewide legal aid organization. You may be familiar with the Texas Law Help website. It's one of the projects that we provide and the services that we provide. Very happy to be here.
Thank you, Karen. Rose Benavides.
Good morning. I'm Rose Benavides. I am from the Rio Grande Valley down in Stark County, where we do need a lot of assistance with low-income families that are requiring this service. So I'm excited to be part of it. I'm even happier to hear there's another non-lawyer in the group that is participating because it makes me feel a little better. But I will give some context. I was a certified paralegal in a past life. I'm now chair the Board of Trustees for South Texas College, where we do offer several programs for legal and paralegal assistants that then go on to get their certified legal certification. So I'm looking forward to finding a way where we can find a balance to offer these services and also provide some curriculum and training that will ease everyone's concerns about the work that they do and how we do it. So having done it for a while, I know how vested paralegals are in working in the world of legal assistance. And so we're hopeful to find a way to make that both mutually beneficial to people that need the services and the attorneys that serve as our mentors with them. Thank you.
Thank you so much, Rose. And I understand we have Justice Eva Guzman online, but not on video.
Good morning, everybody. I can't get on video, but this is Eva Guzman. I had the great honor and privilege of serving as liaison to the Texas Access to Justice Commission and Foundation, and now practicing law at Wright, Close and Barger, and serving as general counsel for the Texas Association of Business. The mission the court has tasked us with is an important first step, and I'm again honored and delighted to join you, and I truly apologize that I can't be with you in person. Thank you.
Thank you, Justice Guzman. Is there anybody else participating who is a participant in the Zoom meeting group that I cannot see and have not heard from? Okay, that's it.
Well, as y'all can see, y'all are a crazy impressive group from various walks of life. I'm proud of the working group that we put together so we can lean on your own experience and your individual expertise as we study this. This is a little premature, but I do want everybody to understand that we're going to divide into some subcommittees to study each thing more closely. And we anticipate The problem with a working group is the working group needs to be a certain size for us to get work done. And if we put on this working group everybody that we needed to hear from as we study this complicated problem, we would not get anything done because our working group would be too big. And so the way we're going to fill in those gaps moving forward is there are going to be a lot of subcommittee membership that is beyond the working group itself. So we're going to be pulling in a lot of areas that we know we need to pull in and that are not represented around this table as we go through our subcommittee work. So I'm sure everybody is pretty impressed with the voices around this table, but there are more voices to be heard. As Justice Busby said, it's going to take a lot of study and input from everybody. So we just wanted to tell the working group and also to anyone who's listening that there's going to be some gap filling going on in our subcommittee work so that we have the voices that we need to hear from. But again, I cannot emphasize enough, as Chairman Myers also emphasized, about how much we want to hear from you as we study. So we might be able to put the email address in the chat so that everybody will know again how we can get input from you if we're sort of missing the gap on this online structure that we've set up here today, which, by the way, is my first time doing a webinar. Justice Livingston.
Oh, I've been
Judge.
elevated.
Okay, that's what happens when we're retired.
I assure you, I've been called worse. So just a couple of questions. One is about timing in terms of the time frame. Do we have a sort of you've given us a scope of work, but I wonder if there is a deadline of sorts that we are striving to meet. And I guess we'll talk more about meeting schedules, but it might be helpful just as an outset to kind of understand what our time frame is to conduct our business.
Thank you for that great question. It is in the referral letter that the Supreme Court has requested a report from us by fall of 2023. And so that is our deadline. When we get to the next steps on the agenda, we'll have kind of more detail about what the working group leadership and Katie, our National Center rep, is just sort of how we hope that will work to make sure that we meet the court's deadline for the fall of 2023.
The sooner we get meeting schedules calendar, the better is really where I was headed with that.
Yes, we are very aware of the need to get dates down as soon as possible.
Right.
So we'll have a little bit more input on general timeframes. And then I suspect after this meeting, we'll start shooting out doodle polls and things like that to get the most participants that we can in our subcommittee work that will work around the commissions, some meetings for the commission are already set. And I'm jumping a little bit ahead too, but our recommendation as a working group is going to go to the commission, and the commission will sign off on our work and issue the final work product. And so we do need to coordinate with the commission's set meetings as well, and we'll be reporting to them continuously, updating them at each of their meetings, which we know the next one is February 23rd. And so the commission meetings will sort of give us that interim deadlines that we need to be working through, is the way I envision that going on.
Okay, thank you.
And then now, without further ado, we've got to know Katie probably in November. I think it might have been when we first started talking to you. You are such a delight. You have been so helpful. You are so crazy smart. I just cannot believe that we have your expertise and your background helping us on this. And I hope I'm going to let you tell the working group a little bit more about your background and why we're so excited to have you because of your unique experience in another state. And so thank you for being here and for coming in person with us. Katie probably will not be here for every meeting in person, but we are so glad she came in today to be with us in person. So Katie.
Oh, thank you so much. It was so kind. Now I want to move to Texas. So I did. I flew in yesterday from Chicago. That's where I'm based. I'm a senior consultant at the National Center for State Courts, and I'm sorry for bringing the Chicago cold with me. But basically a little bit about my history, then I'll talk about the National Center a bit and a little bit about the role we'll play with the working group. So I'm an attorney and I worked in national and international law firms as a litigation attorney. And then once I left, I've really dedicated my career to access to justice issues. I taught in a civil legal aid type law school clinic. And then I worked at the Michigan Supreme Court. Sort of bounced around states for my family needs. And then I spent a lot of time working for the State Bar of Michigan, which, like Texas, is an integrated mandatory bar. And through my work there, I really did a lot of work on policy. And I was on the executive team for our Justice for All Commission, which is like your Access to Justice Commission. And I also chaired a work group that focused on debt collection reform. In addition, I had the opportunity of working on with some groups in Michigan, looking at similar issues, but looking at them from kind of a broader scope. And that's one of the things, after having that experience and then moving to Chicago and, starting my life over with the National Center, I was really excited about the scope of the work that you have set before you, because the focus is truly on access to justice and providing legal services to low-income Texans who cannot afford legal services. The conversations can get very broad when you're dealing with these big issues. And so I think that this is a great opportunity with a more focused role, to make progress, because a lot of times I've been in rooms where these issues are so big that people get distracted because there are so many different ways to look. And so I think that we have a very big marching order ahead of us, particularly with a pretty aggressive timeline, but I think that this is going to be doable, and hopefully I will be able to assist you in finding a solution for Texas. Because I truly agree that there's no one right solution. And so it's going to be a really exciting journey to go with you. So a little bit about the National Center for State Courts. It's been around for over 50 years. And what we do is very similar to what we're doing now, is that we provide support and a national perspective on issues and help states learn from each other. So many times you kind of get in a bubble where you're not really, your life is Texas. When I was in Michigan, we did things the Michigan way. And so what's really exciting about the National Center is you really get to see these different things and kind of understand the reasons why people maybe got to a certain result and why maybe other people get to a different result. And the idea that we have at the National Center is we don't know the solution for you. But what we can do is help you make informed decisions by providing you with examples of what other states are doing, by helping support you. And by also, what I think is also really important that Lisa touched on just a moment ago, is about hearing the voices of diverse groups of stakeholders within Texas. So part of our work with this working group is really going to be conducting interviews and focus groups for a variety of stakeholders. And I can say I have quite a long list of stakeholders, but if you think there are certain people that we should be reaching out to, we want to reach out to as diverse as possible groups of people who would be interested in this work. I think that it would be great for you to shoot an email to that suggestions email list, or you can email me. It's khennessy@ncsc.org if you have any suggestions. And so what we're going to do, along with providing sort of educational materials, background materials, helping with the working group, helping move the process forward, we're also going to be going through and really talking with people. And I think it's really important to have an outside third party. A lot of these people I won't know, but you may know them. But I think that we're going to be able to get honest input from people so that you can understand what different people are thinking in Texas to really come up with a Texas solution to this problem. So I'm so honored to be working with you all. And I'm really excited to get the work started.
Perfect. Thank you so much. We are a little bit early for our, are they available or do we want to?
I mean, are they on the Zoom yet? I wonder.
Do you know, Trish, if they're on the Zoom?
Who are we talking about? Rebecca Sindefer and Lucy Ricca.
Okay.
So do you want to take a break?
I think we should. I think we should take a quick bathroom break and come back. They are scheduled, it's 10:51, so we're just a few minutes ahead. And so let's get some more coffee for those who Kat woke you up at 3 a.m. And then restroom breaks, and we'll be back at right at 11 o'clock. I see.
It's short of me and
It's short.
Right,
It's short.
right.
Say that I'm gonna let Katie introduce before they speak, but I do want y'all to know that as best as we can, we are watching the inclement weather. And so I was thinking we were going to be totally safe. We're getting some reports across the state that there might be ice accumulation with some of our northern Texas friends, not northern friends, where they're actually used to it and we're not. But we are trying to monitor it as best we can, and we'll pivot if we need to make sure everybody's safe. If anybody needs to leave, we totally understand. Again, this is a recorded Zoom. It will be available along with all the materials from today online on the Access to Justice Commission's website. So please, your safety is our priority. And so if you're worried about weather in your particular area, please do what's right for you. And I will have this information available to you as well as to the public later as well. And so now for the education piece, we've talked so much today and I'm just so excited to learn. So Katie, I'll turn it over to you to introduce our esteemed speakers here.
All right, so we are so honored to have Professor Sandifer and Lucy Ricca with us here today. Professor Sandifer is a sociology professor at Arizona State University. As part of her academic research, she investigates how legal services are delivered and consumed, including the role that legal aid, pro bono, as well as the non-lawyers and digital tools can help low-income individuals address their legal needs. Professor Sandifer is a faculty fellow at the American Bar Foundation, where she founded and leads the Access to Justice Research Initiative. And among her many, many accomplishments and recognitions, in 2018, she was named a MacArthur Fellow for her work on inequality and access to justice.
Oh, wow.
We have the best people here. And Lucy Ricca is the Director of Policy and Programs for the Deborah L. Rhodes Center on the Legal Profession at Stanford Law School. She's been a thought leader in the movement to reform regulation of the legal profession to increase innovation, market diversification, and access to justice. And Lucy has really been on the cusp of regulatory reform in the legal sphere, serving as the first executive director of the Utah Office of Legal Services Innovations. And Lucy and her team have published many papers discussing various aspects of regulatory reform. We provided you one in the introductory materials, but you will no doubt see many more papers by her. And without further ado, I'll let the experts talk to you.
So thank you so much. Lucy and I have some sort of background that we're going to lay down. And then, of course, we're happy to talk with you and discuss any questions or ideas that you might have. It's really a pleasure to be here, and I really appreciate the invitation. I know Lucy does as well. These are incredibly critical issues, and it's wonderful that Texas is thinking about how to take some next steps in this space. Because one thing that we've learned is that what we've been doing for 60 or 80 years isn't working, and so we need to think of some other ways to try to crack this nut. So I'm going to start out by reminding you some things you may already know, but I think we often forget the scale of the issues that we're working with. So you all know, because you're on this commission and this is your work, that the whole nation, including the state of Texas, faces a crisis in access to civil justice. Where we see that is in places like courts where lots of people show up without lawyers, or where there are lots and lots of cases where people default, but it's actually much bigger than that. So as far as we know, in our country every year, Americans experience 150 million to 250 million new civil justice problems every year. So some of those you are probably familiar with, like we think there are about 4 million evictions filed every year in this country. Pre-COVID, there were at least 4 million workers having their wages garnished for debt. We know that among Americans with a credit rating, a pretty large proportion of them have a debt in collections on that credit report. We're an aging country, and that's leading to a lot of things that civil justice issues. So one is that you have about 16 million people caring for another adult who has dementia, and that's going to require some legal instruments to decide to clarify who's responsible for different parts of that care. We've got 2.5 million grandparents who are raising their grandchildren. And that involves things like being able to enroll them in school or get them onto health insurance or get them access to healthcare and so on. And you need legal instruments to do those things. And then we have lots of folks who live in rental housing. Some of that rental housing is fantastic, but at least 8 or 9 million people are living in housing conditions that the US Census estimates are so bad that they're either moderately or severely unhealthy or unsafe. What we know from the most recent study from ILS, the Institute for the Advancement of the American Legal System out of Denver, is that of those 150 million to 250 million new civil justice problems every year, about 120 million go unresolved. And these are issues that affect every segment of the population inside your state and across the country. But we also know that they're more likely to affect people who are poor and people of color. So the exposure to these kinds of issues and the kinds of consequences they can create are not equally distributed, but everybody has these issues. And it's not just that there aren't enough legal aid lawyers or there aren't enough lawyers that poor people can afford. The justice gap, as it's sometimes called, goes well up into the middle ranges of the income distribution, simply because lots of things are very expensive, and lots of people don't understand that their justice issues are legal. So historically, legal aid lawyers have been at the forefront of the efforts to respond to this crisis. And a few years ago, I looked at the role of those lawyers in the provision of legal services to low income folks in the US. And what you see is that if you're thinking about it in terms of full-time equivalent labor, so the legal aid lawyers that are funded by the Legal Services Corporation are about 1/3 of that labor. Legal aid lawyers that are funded by other kinds of sources, philanthropic sources, IOLTA, et cetera, are about 1/3 of that labor. And then lawyers pro bono is actually about 1/3 of that labor. And some of that is associates in big firms, but some of it is small practitioners in communities around the country who are doing free work for their neighbors. Even with all of this activity by lawyers, because there are, I think, 1.6 million lawyers in America now, it's a big profession. But even with all of this activity, most civil justice issues never become court cases, and they're never taken to attorneys. So if you're thinking about the civil justice experiences of Americans, they're like an iceberg. So if you're sitting in court or you're in your office, your law office, you're at the tip of that iceberg, which is about 10 or 11%. And the rest of the civil justice issues that people are experiencing, trying to get care for their grandkids, trying to get their houses repaired and so on, are never making it up to that top. And so what feels like a crisis when you're sitting up there is actually a much, much bigger crisis. It's a very, very large scale issue. So the way we've thought about trying to respond to this for years is to get more lawyers. Well, since the 1970s, there are more lawyers than ever. So the size of the US legal profession has quadrupled since the 1970s. But even though we have so many more lawyers, we're actually worse at dealing with the justice gap than we were before. So if you're looking just at poor people, the most recent estimates from the Legal Services Corporation are that 92% of the justice issues for people get no or inadequate service. So that's a pretty big gap, even though we have lawyers to assist them. So one of the things that many folks around the country and the world, both in the world of research like me, but also in the world of policy, are thinking about is ways to build out from that core of lawyers using people that might scale. Now, there's always a temptation that we're going to do this with technology, right? Because technology seems like we can infinitely replicate it and it's going to be accessible to everyone. Technology has a lot of promise, but it's still, at least in the legal space, a lot of promise. So in 2018, I did a study looking at all the consumer-facing legal technologies I could find in the US. And what you see is that those techniques don't incorporate what we know about what people need. So we know that people need help that's timely. It shows up when they realize they're in trouble. It's targeted to the problem that they actually have. It's trusted in the sense that it's coming from someone who they believe, or an organization who they believe has their best interests at heart, and it's transparent. So it enables them to understand what their options are, what the costs in time or money or other kinds of trade-offs might be. And very few technologies, there are some, have those elements. And very few technologies operate at anything like scale. So remember, we're talking about 150 million to 250 million new things every year. One of the best scaled technologies to assist people with justice issues is Law Help Interactive, which lets you fill out forms on a web interface. They're doing single-digit millions of people every year. So that's very impressive, right? Those millions of people are being helped in a way they wouldn't be without Law Help Interactive, but that's less than 1%, 2% of the issues that are out there. So technology is not scaling very fast. And of course, not everyone can use it. So there are issues of bandwidth, there are issues of hardware, there are issues of computer literacy, of text literacy. There's some groups in the population that are probably never going to use technology as the way they interact with justice. But those technologies could be really valuable in the hands of another human being. And so part of what you all are thinking about is how can we expand that workforce of justice workers to give people access to their own legal system. I'll tell you the short version of the punchline on the research findings for community justice workers is that they can and do, where they're permitted, provide effective, culturally appropriate, competent, and accessible assistance for many of the kinds of justice issues that people experience, including low-income populations. So how do we know this? So there's enormous potential here. How do we know this? Well, in the United States, we're actually already doing some of this. So people who are not lawyers can already represent other people in a range of issues, most of which are in the federal space. So there are authorized non-lawyers who represent folks in Social Security, in unemployment, in immigration. There's a range of state tax courts that allow people who aren't lawyers to represent. And the research that I and others have done suggests that people are happy, the public is quite happy to work with these kinds of representatives, and that their work can be just as good and sometimes even better, and by better we mean competent and effective, than the work of lawyers. Now, there are other jurisdictions where this kind of practice is much more widely permitted. So the marquee example of that would be the United Kingdom. So people in the United Kingdom can give legal advice without being licensed attorneys, either for free or for pay. And there are a wide range of advice providers around the country, some of which are funded by the government. So the Citizens Advice Bureaus are available in every community. You can access them by the web, you can access them by phone. And those are trained community volunteers who will explain to you what that crazy paper you got in the mail means and what your choices are. And if you say don't show up at court, that means you've defaulted and this is what may happen to you, right? So this very fundamental information and advice about how to respond to very common justice issues. In the UK, there's a great study of this work done by a professor named Richard Moorhead that did blind audits of the legal work. So you have legal work, it gets done. This is across a range of civil fields. So employment, immigration, housing, all that kind of stuff. And so you have the legal work, you take the names off of it and you give it to an attorney. The attorney doesn't know who did the work. And you say, okay, rate this work. Is this passing work? Is it excellent work? And what you see in this study and in similar studies that have used similar methods is that everybody screws up about 20% of the time. So as professional workers, as you all have, you know you make mistakes, right? So lawyers will get a failing grade about 20% of the time. And non-lawyers get a failing grade about 20% of the time, which could discourage you depending on your perspective. Or you could say, wow, that's great. 80% of the time, people are getting pretty decent service, whether it's coming from an attorney or from someone who's not an attorney. The thing that's really striking about these studies is they find that people who are not lawyers are about 8 times more likely to give work to do work that's rated as excellent. So 80% of everybody passes, but the people who are not attorneys are more likely to get A's, if we want to use university language, on their legal work than people who are attorneys. Now, why might this be? Well, because those people who are not attorneys are specializing in that one thing, and they become quite expert in handling the issues around the one thing that they specialize in, so they get really good at it. So there's tremendous potential here for people to be very good at this and to do it very effectively. Now, if you look at the way you can do this, there's a range of different ways that you might go about making this new kind of activity possible. One is to create a new kind of professional, right? So you license somebody to do limited legal work. Like you would license a nurse practitioner, you would license a physician assistant. That's one way to do it. But it's not the only way to do it. And Lucy's going to talk more about the sort of the concrete mechanics of this, but I just want to highlight a couple of recent examples about the way authorization of this kind of practice is being permitted. So in the state of Alaska, Alaska Legal Services, which is the LSC-funded organization in Alaska, got a waiver from the Supreme Court with unanimous support from the Alaska State Bar, so that when Alaska Legal Services trains community justice workers who can go out to remote communities, because there are hundreds and thousands of people in Alaska who live in places that you cannot access by roads. And there's certainly no attorneys living in those remote communities. But there are community health workers going out there and other kinds of people who are already there. And so Alaska Legal Services has the authorization to train those workers to provide legal services when they're out doing other things. Those legal services are going to be culturally appropriate because they're from people's community members. They're going to be accessible because they're already there, right? So that's one way to think about doing it. Upsolve is an interesting tech platform that helps people file simple bankruptcy. And when you tell it the facts about your circumstance, if your bankruptcy is too complicated, it has an off-ramp and it will send you away and tell you that you really need a lawyer. Upsolve has sued the state of New York in the person of its attorney general to be permitted to work with a pastor in the South Bronx to train that pastor and his parishioners in how to give their neighbors legal advice about debt claims, which, as I said, is a very, very common thing that happens to populations around the country. That went through the first round and is now being appealed in the Second Circuit. The state of Delaware was looking at its law and realized that it had a strange legal inequity. So if you were a landlord, you could have a non-lawyer who was a registered agent represent you. But if you were a tenant, you could not have a non-lawyer represent you. And that struck them as something that wasn't quite equitable. And so they created a tenant's representative. So now you can be represented by somebody who's registered with the system on either side of an eviction case in the state of Delaware. And then, of course, Utah has its sandbox, which Lucy will talk about. But a sandbox is a different model. So rather than saying we're going to change the rules and go, a sandbox says we're going to release the rules. We're going to let people apply to relax the rules, and then we're going to watch how that goes. So it's an evidence-based regulation. And in the sandbox, then entities apply to come in. There are fantastic examples of what's possible there. So there are domestic violence advocates who are already doing their thing, right? Talk about something that can scale because it's got federal VAWA money under it. These advocates already exist in most communities around the country. But what if they could actually be authorized to give the women and other people they're working with legal advice, right? What if they could be more empowered to give more effective and more complete service? There's another project in the sandbox about medical debt, which is the source of those debt claims. And medical debt is a really important one. And so dealing with medical debt, being able to give advice, being able to help in negotiations when you're thinking about a debt. So there's really, really amazing opportunities when people are specialized and trained and authorized to build out from the capacity of legal aid, which is never going to be enough, to provide people with resources that are not just bigger, but more accessible and more effective, linguistically accessible, culturally appropriate, present physically near you, all kinds of things. And so it's really exciting, as I said, that Texas is considering this. And I think now, as Lucy's going to talk about sort of, if you were going to do this, how might you do it?
Thanks, Becky. Thank you all for having us here. It's a real honor, and I'm very appreciative of the opportunity. So Becky gave a really good snapshot of the challenge and particularly the opportunity of thinking about expanding out from legal aid in terms of building out additional capacity for the provision of legal help. And I want to kind of take you all through a little bit of the nitty-gritty of how this might be done, or at least how to think about it as you all are thinking about your path toward a potential reform platform. So Becky, talked a lot about individual people layering into an expanding legal aid service provision. And there are two main ways to kind of think about that expansion. One is increasing the types of people, individual people that can provide legal services. And the other is adding in new organizations that are authorized to provide legal services, or expanding the authorization of existing legal organizations. And both of those have reform components, and they overlap, but they can be, it sort of helps to think about them distinctly. So the first piece is expanding legal roles in our civil justice system. And this is, adding more people, different specialties, working in different communities, a lot what Becky talked about. And we think of this as role regulation. So rethinking and regulating the types of individual roles that are authorized within our civil justice system. Paraprofessional licensing is one kind of really simple example to think about, because in paraprofessional licensing, you just add a new professional role into the legal system, but you don't change very much about how that system operates as a regulatory function. So this is what's happening in a lot of states, right? So Utah, Arizona have now licensed paraprofessionals. Washington State has the triple LTs. Oregon, Colorado, Minnesota are all moving forward on licensed paraprofessionals. And the distinguishing characteristic of this is it is sort of a state-run program, right? It's authorized through the Supreme Court, implemented through regulation by the bar, very similar to how we authorize and regulate lawyers. And it can help ameliorate the justice gap potentially significantly, although it'll probably take some time to get there. But it still relies on individual providers kind of serving people one-on-one. The other piece of this is entity regulation, which is taking a step back and looking at organizational authorization. It's different from role regulation, but there's a lot of overlap because you can have regulated roles working in authorized entities. Essentially, in entity regulation, you pull back and the level of oversight is at the level of the organization, not the individual people inside, or in addition to the individual people inside. The simple way to think about this is, if you think about what we have currently, would be regulating law firms in addition to lawyers. Some states do have a component of that, DC, New Jersey, New York, I think Rhode Island. And entity regulation recognizes that, like, in our modern economy, more often than not, an organization is actually kind of the main hook of provision of legal services. When a person thinks about who they're dealing with, I think about dealing with AT&T, not any individual person in AT&T. So entity regulation is an important piece to think about as you consider your path to reform, because it has the potential to speak to that scale issue that Becky mentioned, because organizations can serve more people, particularly if they're allowed to diversify the way that they offer those services across multiple providers. So thinking about entity regulation specifically, there are a number of ways to go about it in terms of which changes to the rules may or may not need to be made. And this is something that your group will have to think about and debate and consider which is the best appropriate avenue for the goals that we're seeking to meet. Entity regulation can mean rethinking Rule 5.4 to allow non-lawyer ownership of organizations, of legal services organizations. This is the approach that Arizona took in their ABS licensing scheme. They repealed Rule 5.4 altogether. They shored up some of the other rules that relate to professional independence and the ethical duties of lawyers within such organizations. But 5.4 is no longer on the books in Arizona. And they created an entity licensing regime for new legal service organizations that are owned either in whole or in part by non-lawyers. So the only change that they really needed to make there was the change to 5.4 and then to develop this licensing regime. They didn't change anything about who can provide the services within those organizations. So it is still either licensed lawyers or licensed legal paraprofessionals, which was a separate track of their reform. Entity regulation can also mean reforming the ban on unauthorized practice of law without doing anything about 5.4. And a lot of the examples that Becky talked about, Alaska, Alaska and some of the entities in the Utah sandbox are examples of this. So you can authorize entities such as community-based organizations to offer legal services, and you can regulate those entities rather than the individual providers in them. You don't have to license each individual provider necessarily, which increases the efficiency and flexibility for those entities. And Alaska Legal Services, Upsolve, and Timpanogos Legal Center and the Medical Debt Legal Advocates programs in the Utah Sandbox are all kind of examples of this, and with different approaches. But each one of them recognizes that ultimately it's the organization, whether a community-based organization or not, that will be on the hook for the ultimate provision of legal services. And within that, they are given more flexibility with regard to UPL for non-lawyer provision. So that's one example of reforming, layering in organizational provision of legal services without doing anything that touches on 5.4, but simply giving those organizations the flexibility to use their non-lawyer service providers to more actively address the legal needs that they're facing. And this can be for traditional direct legal services providers, such as a legal aid organization or not, but it holds the organization to account for the quality of the service provided. So there are also good reasons to think about having both 5.4 and the unauthorized practice of law on the table when considering entity regulation. Becky touched on this, but the scale of the justice gap is so significant that we need to consider the possibility of allowing services that will scale. And we need to consider how to drive the kind of business and technological innovation that at this point, as Becky noted, there's not been a lot of really impactful technological innovation in the legal services space. We would like to think that perhaps we should consider layering in additional capital and additional ways to think about risk and development through expanding the types of ownership that organizations can hold. So the currently authorized legal business form, traditional law firms, just doesn't allow for this. But allowing for-profit legal entities financed by investment capital and using a variety of service providers, such as lawyers or lay providers or tech at a variety of price points, may help to solve the challenge of all of those folks who could pay something for legal help and something maybe a lot less than what lawyers currently charge, but something. They just can't pay that high hourly rate that's so indeterminate often when they are faced with a legal problem. So this is the approach that kind of guides the Utah Sandbox. And within that, of course, you can have nonprofits, but there's also a recognition that this challenge is really expansive. And so we want to drive toward expansive solutions. In the Utah Sandbox, it's an entity regulation approach, but both 5.4 and an authorized practice of law are on the table for those entities. They can come to this Utah Sandbox and say, we would like to do both of these things or one or the other. And regardless of what's being proposed, the regulatory approach is on really focused in on consumer protection. So it almost doesn't matter where the service provision is coming, the regulatory approach is the same. And we can go into that if it's of interest, but it does not, we don't need to spend time on it right now. So in the Utah Sandbox, you have community-based organizations, as Becky mentioned, domestic violence advocates, medical debt legal advocates, and we have additional applications in the pipeline. And there are other types of entities as well that are serving those folks who may not necessarily qualify for legal aid 100% of the time, all the way up to moderate income and middle class. So for example, we have an organization called RASA in the Utah Sandbox, which is a B Corp expungement focused corporation that is offering expungement services at a very low price point, primarily provided by technology and non-lawyer providers. There's no direct services provided by a lawyer from that entity. And given the number of folks that have a criminal record, that is a potentially really impactful model. We also have several organizations that are using a variety of service methods. So they are using technology, they are using non-lawyers, and they are using lawyers to provide services. And they have non-lawyer ownership at a variety of levels. Some are very little, some are quite a lot. But there's just a lot of flexibility allowing for the organizations to propose, this is how we would like to solve this particular, our particular product in this area. So for estate planning or small business services, there's a lot of variety. But the key is that both the unauthorized practice of law and the ownership piece are on the table so that you can drive that investment to drive the technological development and the scale that we hope to see. Admittedly, it's a challenge because it is only in Utah that this is possible. And so the scale is de facto relatively limited because it's one state, but we hope to see benefits within the state that other states can look to and say, well, this might be worth trying. So the key is for all of these entities and why I think, regardless of where you're focusing, the primary point that you should have in your sights is the expansion of the unauthorized practice of law, because it enables a diversity of services at the places where people need them, as Becky said, and at a variety of costs and possibly, free. I do want to note that at least one reason to think about including 5.4 in your scope for reform is that we do know that the two largest consumer-facing legal service providers in the country existing are non-lawyer owned companies that are using technology primarily to provide legal services. And those are Rocket Lawyer and LegalZoom. They are already providing services across the country to millions of people every day. They are both taking advantage of reform, LegalZoom in Arizona and Rocket Lawyer in Utah. And they are layering in lawyers in both states to supplement their tech services. So it's an additional opportunity for lawyers' employment. And so it cutting off, developing a reform that's targeting consumers that cuts off those organizations is just something to pause on, I think, and think about. So what are we seeing as reform moves forward? We produced a report out of the center at the beginning of September of 22. I think you all have it in your materials, that looked at the reforms in Utah and Arizona. And you can look at that report in detail, but I just wanted to highlight one specific conclusion out of looking at both Utah and Arizona's existing authorized entities, which was that there do not seem to be any evidence at this point of harm to consumers caused by these reforms. At the time of the report, and at least at the time that I last checked, there had been no complaints filed in Arizona against any of the newly authorized entities under the ABS licensing regime. Utah has had some complaints come in. It's a different model. It's a more proactive. Every month, the entities are required to report consumer complaints to the regulator. And there, at the time of the report, there were 11 complaints for every over 2,000 services delivered. Only 6 actually related to potential harm, and all were resolved satisfactorily. So, lining up with Becky's comments with regard to the evidence of non-lawyer provision and the satisfaction and the evidence on quality there, I think there's not a lot of merit to the concern that people will be harmed by these services. And so the key is to think, how do we want to best implement it that we're going to impact the populations that we most want to impact? So I'll pause there.
I think we may be at a point.
Yeah, I would welcome questions. We've got about 20 minutes with these panelists. So that was a lot of information, important information. I'm digesting it all, and I've been reading about this for several months now, and there was still a lot, even to me. So I guess I'll start just so everybody will feel free to ask any question, even if this comes across as a stupid question. When you're doing entity-based regulation, who is regulating that in those states? Is it a separate entity who regulates lawyers? And it's probably different per state, I recognize, but if you could give me an idea of who actually is overseeing the entity-based regulation.
Sure, great question. It is different in Utah versus Arizona. I'll start with Arizona. Arizona they've created a new kind of committee under the Supreme Court. This was all run through each of the Supreme Courts in both states. Arizona has a new committee that assesses applications and makes recommendations. And I think it's staffed by at least 1 FTE, possibly 1.5 or 2. They have a program manager that kind of oversees the process. But the applications come in, they're reviewed by the committee, and then they go to the Supreme Court for ultimate determination. And then they're authorized, their materials are put up publicly. What they have done is essentially, though, leverage off the existing disciplinary system. So discipline will be run through the bar's disciplinary system. So they haven't changed. It's interesting because they've created this new licensing regime for alternative business structures that, has a fair amount of components. They require, for example, a legal compliance officer. They have every owner, at least I think it's 10% or more owners are called authorized persons and have to separately kind of disclose, go through a background check and, have to kind of disclose their background and what have you. But it's all on the front end. So there's a kind of robust review process on the front end, but then the back end is very similar to how we treat lawyers now. And in Utah, it's just an entirely different objective with regard to the sandbox. The goal has always been primarily to drive as much innovation as possible. So keeping the front end bars quite low, but developing a new, really empirically driven regulatory approach on the back end. And so because it's such a different approach, it requires more of an institutional shift than perhaps the ABS structure does. So Utah currently now has the Legal Services Innovation Committee, of which Becky and I are both members, and we're a committee of the court. And we do the front end review of applications and recommendations to the court. But then there's also a separate Office of Legal Services Innovation, which is the executive function of this work. And that includes this relatively robust data component, ongoing monitoring and interaction piece on the back end. And it also includes So there's monthly data reporting that the entities have to do in the Utah sandbox at a very discrete level. It's at the level of services provided. So if someone comes in and says, I want a will, that gets reported to the office, not the person's name, but an anonymized version. That includes complaints. It includes kind of who provided the service, what service was sought. So we're learning a lot about the types of services that are on offer in the sandbox. It also includes for some of our higher innovation entities, the ones that are using technology and non-lawyers to provide services, it includes an audit function where after a beginning kind of period of offering services, they undergo an audit of their services for quality. So it's a completely different system and does require a different level of kind of resource investment.
Thank you very much for these presentations. Lucy, I was wondering if you could specifically address what you perceive as the potential of an entity regulatory approach or entity reform approach that either didn't depend on a profit motive, was dependent on a nonprofit scenario, or perhaps relatedly, is focused on the client population that is currently served by legal aid.
Yeah, I'll let Becky weigh in too, but I think the examples that we're starting to see bubble up, particularly that of Alaska, but beyond Alaska, because Alaska is focused on Alaska legal aid, but I think it's identifying community organizations that already exist either directly in legal or quite ancillary to legal, so social services organizations, and so allowing those organizations more leeway with regard to an authorized practice of law. And that means looking at unauthorized practice of, I mean, it's a very broad brush, right? Unauthorized practice of law. But it means looking at unauthorized practice of law. It also means looking at the supervisory requirements and saying, maybe we can lighten up on this a little bit and, encourage these organizations to allow their non-lawyers to do more without the kind of direct supervision that we've historically understood Rule 5.3 to mean. So that would be my kind of instinctual answer on that. It's really early days yet, but I think that identifying organizations that have the bandwidth and the community trust existing, and then allowing those organizations to develop legal advice that is offered independently by non-lawyers with some kind of lawyer supervision if that's needed, but not necessarily as heavy-handed as 5.3 can be interpreted to be. But maybe I'll kick it to Becky to add on.
The only thing I would add to what Lucy has said is to go back to this issue of scale, right? So I do not have the solution to the problem I'm about to toss to you, but I think it is an important one to be thinking about. So imagine how we would have to scale something that is a nonprofit organization that would be charging no fees for whatever it's providing to, instead of 1,000 people, 100,000 people or 1.5 million people. You have to have a magical source of infinite subsidy to do that. And so there are, sometimes those exist, right? If you could attach to a federal source of funding, that might be a way to scale, but lots of the issues that poor people experience are state law issues. They're not federal issues. And so then the question is there a way that you can think about allowing business models that let an organization serve the actual need? And so that might be having a fee structure for some clients, so over some income level, and then that fee is subsidizing the service that you're not charging people for who are below that income level. But one of the things that we see in Utah is it is challenging for organizations that do not have business models that involve generating revenue to scale up to serve the need. And so thinking about ways to set up an environment that let that happen, I think is a problem I would toss to your group.
Since you're the experts and you've been studying this, do you have any ideas about where those types of revenue streams might come from? One of the members of our group has already suggested to me the example of medical legal partnerships and the fact that within the healthcare system, which of course has its own funding challenges, but there is a source of revenue. And so meeting this client population when they are in a hospital and may have legal needs in addition to healthcare needs is a possibility. Is that something that you see as being in the scope of this, and are there other examples you can think of?
I think that's absolutely a possibility. What makes medicine special and wonderful is insurance. And the ability to take insurance that's designed, that, was originally designed for medical care, and to be able to understand the legal assistance as part of medical care. And so that's definitely a place we could expand. And if this group, there is some empirical research on that we can share with you if you let us know. I think not everybody's justice issues, though, are attached to their health issues, right? So maybe my issue is that I'm a wage and hour worker and my employer's not paying me overtime, but I'm owed that overtime. And both that family and the community that it's in have a really strong interest in getting that person paid. A medical legal partnership is not necessarily going to connect with that. So if we allow all kinds of things where we let people take a piece of what they get, right? That's what contingency fee lawyering is. Are there business models like that you could design around money claims, for example, so that it's possible for the organizations to continue to function, but you're not necessarily charging the full cost of the thing to the person that you're serving. And you're allowing models of producing the service that make it cheaper than kind of bespoke one lawyer doing your case and so on. And you're creating an environment that lets an organization invest in technology in a way they may not be able to now, so that if there's an easy way to routinize something and computerize it, they have access to the capital to do that.
I have one question pertaining to what was referenced. I think, Lisa, you referenced a committee that both of you are on, and it strikes me that you might be serving as volunteers. I was thinking about what happened in Washington State with the sunsetting of the program, and one of the reasons cited was the cost of administering the program, and also the level of interest, I think, was a factor. But can you speak to what's happening, and in particular the projects that you're involved with, the committees you're involved with, and whether you're serving in a volunteer capacity or if there's compensation entailed?
So Becky and I are both serving in volunteer capacity. The staff members of the office are paid, they're in consultant capacity at this point. The court is determining, how it wants to kind of approach sustainable staffing over the long term. But yeah, doing this requires putting money into legal services regulation that we've been able to avoid, I think, because we have this self-regulation model for lawyers. We don't actually really properly regulate legal services. That's just quite clear. And so if we want to do that, which is, I think, is what this group is at least in part about, to make this work better for the people that we are supposed to be serving, it's going to take more money put into different places. At least that's my strong feeling. Particularly if we want to have an approach that that is less driven by anecdote and that is really focusing on consumer protection, because that takes work and that takes data. And both of those things are not something that we have historically had anything to do with in the legal profession in terms of regulation. And so yeah, there are additional resources required. What we have moved toward in Utah is an ambitious project. And so I think, the startup costs were ambitious, and we were initially funded by grants from the State Justice Institute and the Hewlett Foundation. But a lot of that initial work has been done, at least in the Utah context, for that regulatory model. Same with Arizona. There's the model there now. So that initial kind of startup, investment has been done by those two states, and the paraprofessional licensing as well. So I think there's drafting opportunities, let's say, for states that are considering this now to take advantage of the work that has come before.
Thank you.
I am going to read a question from Judge Spencer, which is this. Is there backstream review to monitor money being made to prevent simply parasitic work with poor people? I am generally offended by the concept of for-profit people making money off the backs of the mentally ill or foster children in the way we have seen parasitic activities in hospice or pharmaceuticals, et cetera.
So in the sandbox, we know what people paid, we know what they wanted, we know what they paid, and we know what they got. I think when we're thinking about parasitic activities, the question is, where do you, if that's something we want to, as a group, stop, where do you regulate that? So is that an issue of consumer protection that the state consumer protection agency should be working on all the time anyways? Or is it a particular issue to law? And then how would you, are you doing it with lawyers? How is it being regulated with lawyers? And then if you were thinking about expanding the set of providers that could work with that population, how would you have those consumer protection measures in place in that new kind of enabling environment? But it might not be, it's tempting when you're starting a new thing to think this new thing is going to solve all of the problems that we have. But what these kinds of models can do is they can create an enabling environment that expands service, and they can do that in a way that it's organized specifically around consumer protection. So the question is then, how would you put that in your regulatory scheme?
Yeah, just really quick to follow on Becky's point. We thought very hard in Utah, and again, it's a different approach than sort of what's been done in other spaces, but we thought very hard about, what are the actual harms that we're really worried about in the context of legal services? And primarily it's poor quality legal services, right? Whether it's a lawyer or anybody else, that's what we're really worried about. And, we have these series of rules for lawyers that are kind of proxies for that harm, but we wanted to look directly at it. And so that's one major component. But the other is, did you get sold something you didn't need? Did you get sold a bill of goods, which we know is a concern because of the information gap between legal services providers and lay people. And so we do look specifically at that. It may not, the word parasitic is a loaded one, but I think that at least looking directly at what's happening, how, what services are being provided for what fees, and whether there's a concern that people were sold something they didn't need is the way, at least specifically from a consumer protection standpoint, that the Utah Sandbox has chosen to address it.
Do you have enough information or data with the different models to determine at this point which models you get the most participation in? And I may have misread the Washington, so I was dismayed to see that Washington was sunsetting their group, but it kind of sounded like it just costs too much and there just weren't that many, triple LPs or whatever the right acronym is, and so I was curious as to whether you have enough data to determine, which models by, non-lawyers or whatever it is you have set up.
I think one of the things we know from a range of research looks at this is creating a new role and sending it out into the world requires a lot of consumer education, right? So part of the issue with the triple LTs in Washington was no one understood that they existed, what they were, what they could do, how to find them. Because the state is the bar is a regulator and the court is a regulator. It's not a marketer of the services. And so that's why it's probably the case that building on to things that already exist, that people already know about, that are already in their communities, will be more effective. So if I were going to guess about what works in the Utah Sandbox 3 years from now, I would say something like the Timpanogos domestic violence entity, which is using people who are already there, that people have already, that consumers or the public has already heard of, and expanding their capabilities is going to be more effective at reaching people and have more uptake than a whole new thing that no one has ever heard of and doesn't understand what it does.
I've got a question about the Utah sandbox, and I'm unclear whether that is a temporary experimental sandbox. Is it a space for experimental work? And if that's the case, what's the experiment time? How long are the entities given to stay or go? And what happens if they stay?
Yeah, so technically, yes, it is a temporally limited policy space in which entities can try out new things. The court initially authorized it for 2 years and then quickly realized we weren't going to see that wasn't enough time because companies take a while to launch, and the court needed more time to see what was coming out of the sandbox. But always from the beginning, the idea was we want to authorize this, and we want to be able to then look at what happens and then make some decisions about whether we change the rules and how. And so it may end up being that the court decides to change Rule 5.4 and go the Arizona route and create an ABS licensing regime. It may be that the court decides actually 5.4 is not where it's at. We want to expand UPL for community-based organizations, and that's the route that we're going to go. It is unclear at this point, because the approach is meant to be data-driven, and the court is getting really robust data reports every month. And ultimately, the discretion is with the court to decide what it wants to do. What the court has said to the public, the entities from the beginning is, as long as you're in good standing, if this program is sunsetted, sort of similar to what happened in Washington, or any aspect of this program is sunsetted, you will be, if you're in good standing and there's no evidence of consumer harm, we will figure out a way to allow you to continue to offer services. But that's an issue that they're going to need to grapple with at that point. There could be as well a way that this shakes out, that the sandbox doesn't go anywhere, because the sandbox is quite a useful tool, a gatekeeping tool, for example. We have the bar exam and the moral character requirement for lawyers. The sandbox allows a really flexible, focused on innovation approach that can be something that new entities have to pass through before they're given any sort of ongoing authorization. And I think that's a really useful function, a sustainable function of a regulatory sandbox, particularly as we see the kind of exponential acceleration of generative AI possibilities, which we've only just begun to see with this Chat GPT bot. But I think part of the development of the sandbox was to create a way for technology that can make a difference and that can provide legal advice to be authorized when our traditional system just really can't do that. You can't do a moral character exam for an algorithm. So, and often we don't even understand how algorithms work. And so if we can look at the outputs on the back end and we can see that there's no harm being caused, it almost doesn't matter what happens at the front end, if we're very careful about how we identify the harms that we're concerned about.
I have a quick follow-up question. Are the consumers of the legal services being advised at the front end that these are experimental services?
No, they don't have a disclosure with regard to the sandbox, but they do have disclosures around, hey, this is something different than a traditional lawyer, and there may be implications for you in that. So for example, if it's a non-lawyer provider, you may not be protected by confidentiality or attorney-client privilege. And so you need to just understand that as you engage with this service. And that was the approach toward, again, trying to allow the market to have more of a presence in driving people's ability to choose, I want to pay this much for this service versus that much for a lawyer.
But I guess Lucy, there's also an opportunity for consumers to report complaints and that sort of thing. And that's mentioned, it sounds like, since they're being tracked.
Yeah, so every entity is required to report any complaints that come into them. And honestly, this will not surprise any of the lawyers in the room. A lot of the complaints are, this person didn't call me back, that kind of thing. And so, yeah, we're familiar with a lot of that, but which is not, that's a communication issue, right? But the actual complaints related to harm, as in I paid for something and I didn't get it, or this person did not, the will that I had isn't what I wanted. We're not getting complaints like that very frequently. And to the extent that there are ones that we say, this actually may trigger one of these harms, the entity has every time made the consumer whole, resolved it satisfactorily to the consumer's satisfaction and the entity's and our satisfaction. I think, down the line, there's more to be done. And Becky probably agrees with me on this in terms of, having more transparency for consumers into entities that are authorized. And so we have a plan for a dashboard that will update according to, complaints filed or what have you for individual entities, sort of like a Better Business Bureau. But we have not implemented that yet.
Lucy and Becky, thank you so much for your time and your expertise. And we learned so much today from you and just cannot thank you enough for your time. We're going to move on to our next panel just so we stay on track. But thank you. And I hope that you'll at least Shannon and Michael.
Thank you.
For the chance to be with you today. See you.
Okay, Katie, do you want to introduce our next speaker here, Craig?
Stacy Butler.
Yeah.
So, I can tell you a little bit about her, and then hopefully she will be joining us shortly. But Professor Stacy Butler is the director of the Innovation for Justice program at the University of Arizona College of Law. She has a long background in community advocacy and access to justice to low-income communities. And her research really focuses on the application of human-centered design and innovation to social justice issues. So we thought that she would be really good because her research is really focused on these low-income communities that we are interested in. And I was really excited. Among her many works, Professor Butler has just completed a new paper that we will be providing you shortly. It was not in your introductory materials, mostly because it had the word draft on it. But I think it's going to be very important to our working group study. And that paper is called Leveraging Regulatory Reform to Advance Access to Justice. And so we'll be providing that report to you shortly with other materials. But now I see that Professor Butler has joined us and we are so thrilled to have you. So we will kick it off to you. Thank you for joining us.
I'm so happy to be here. Can you all hear me okay?
Yes.
Great. I am going to share my screen, I hope. All right, are you all seeing a Google slide deck? Oops, there we go.
Yes.
Okay. I'm extra happy to be here because I see a former I4J student in the room, Andy Workus, who actually worked on one of the projects I'm going to be talking about today. So it's exciting to see him out in the real world and being a part of regulatory reform. So I'm Stacy Butler. Thank you for that kind introduction. I direct Innovation for Justice. We are a social justice innovation lab. We design, build, and test disruptive solutions to the justice gap. We're housed at both the University of Arizona and the University of Utah, in the law school at Arizona and the business school at Utah. So we've really been uniquely positioned to look at the issue of regulatory reform in these 2 states, which have been really the front runners in adopting regulatory reform strategies. As the introduction mentioned, my research interest is really on access to justice for low-income populations. And so for the past 4 years, we've been working on how can we leverage these emerging regulatory reform opportunities to really create new service models that are specifically designed for the low-income community. Over the past 4 years, we've actually built out 3 pilots, and we have a 4th project forthcoming. In Arizona, we have licensed legal advocates. These are advocates in the DV space. They work at a DV social service provider. They have permission from the Arizona Supreme Court to give limited scope legal advice to survivors. In Utah, we have 2 projects in the sandbox, training community health workers and financial counselors in the nonprofit sector to be able to give legal advice on medical debt. And just last week, we got approved for a new project in Arizona. We'll be training housing stability legal advocates. And this is, again, upskilling people who work in the nonprofit sector, the frontline staff that are interfacing with tenants to be able to give them on-time legal advice about housing and stability. We're working on a project now in Utah that you'll see some of the data from this project is shared today. And this project focuses on, in the context of patient care and healthcare, we have medical legal partnerships, but what is the capacity for non-lawyer civil justice problem solving in patient care? So our work across these 4 projects all informs the findings that I'm going to share with you today. So we start every project at I4J with empathy. We want to understand the failures of the legal service model from the perspective of the population experiencing that failure. And so in the research community, when regulatory reform first emerged, I think we were all very hopeful. There was a lot of speculation, like this is going to be it. Now the nonprofit sector is going to get involved. They are going to start training their social workers and their counselors and their navigators to give the low-income community legal help. That really has not happened yet, largely in the regulatory reform effort. And we think maybe one of the reasons for that is that states that are onboarding regulatory reform strategies haven't been including the community and the nonprofit sector in the design of the reg reform system. So when we look at the membership in both Arizona and Utah, what we see is that these are judge and lawyer driven initiatives. I don't know who's in the room out there in Texas, but I do first of all want to say thank you for thinking about regulatory reform for your state. And the judges and lawyers that have driven this effort in Arizona and Utah have absolutely championed the effort. It wouldn't have happened without them. But I want to talk about some of the things we're seeing because we haven't been including the public and particularly the low-income community and the organizations that serve them. So our research focuses on the perspectives of 3 key stakeholders. And I should say I can probably cover this in about 10 to 15 minutes. So hopefully we'll have time for questions after the end of this slide deck. But so we've talked a lot to consumers, we've talked to community-based organizations, and then we've worked with regulatory reform decision makers in both states. Along the way, we discovered there really is a 4th stakeholder in our work, and that's us. We've been the design hub for the work. So I'm going to focus on those first 3, but I'll touch a little bit on the value, I think, for states considering regulatory reform of working with a design hub. So when we talk to consumers, we want to know things like, will they trust someone who's not a lawyer to give them legal help? What will effectively nudge them to engage with advocates who aren't lawyers? And then what kind of services do they want from legal advocates who aren't lawyers? And what we found is, yes, generally consumers will trust someone from their community who has legal training, but not a JD. In fact, they may trust that person more than they would trust a lawyer. In one survey we did on our housing project, 66% of our consumer respondents were interested in getting legal help from an advocate as compared to 16% wanting help from a lawyer. Generally, when asked who they trust the most, consumers preference the organizations that they work with in the nonprofit community and their friends and families and themselves more than they trust the civil justice system. In addition, yes, consumers will trust someone if they know that person is, when we talk about what kind of training they want to see in their advocates, they want to have that same person help them through the arc of problem solving. And that's really because they are used to intersecting with a nonprofit sector that provides holistic services and really tries to work with and within community across different dimensions of problem solving. They do want to know their advocate is properly credentialed. And so our work with the Supreme Courts in Arizona and Utah has been very important to have their endorsement on the projects. They want to know things like how long has that person worked in the field? Where is their training from? And then most importantly, I think this has been something that I've really has been really meaningful to me in this project is consumers want advocates from their community. They want someone who looks like them, who understands the problems they're experiencing, and who feels like a trusted member of their community. When we look at what kinds of issues they want help with, regardless of the type of help, what we hear from consumers and the organizations that serve them is the importance of trauma-informed care and the importance of upstream intervention. When we look at different issues, sometimes that varies. So for survivors, the survivors we interviewed reported really wanting help with an urgent legal issue, whereas people experiencing housing instability want help at the first sign of a problem. So it is, I think, important when you're building out the scope of new services to think about what is the point in time when someone is most able to receive help, most able to navigate with help. But in general, the earlier, the better. So then we talked to a lot of community-based organizations trying to understand whether they knew about the opportunity to provide legal advice potentially through regulatory reform, and did they want to do that? And if they did, what were the barriers they were seeing in the regulatory reform structures that are emerging? So are community-based organizations aware of the regulatory reform opportunities in Arizona and Utah? Generally, no. Most of the time when we do a start of a project and we do community engagement, we are the first time that nonprofits are hearing about the opportunity to get in the sandbox or get approval as LPs to provide services. And when they find out about the opportunities, they're very excited. They really do want to include this type of work in their services. They are pretty frustrated. Community-based organizations are pretty frustrated with the siloing of legal services. So for example, our DV service providers are helping that survivor with housing, education, counseling, childcare, all of the different issues that a survivor faces when they exit. But then when that survivor has a legal issue, which they will, they'll need a protective order, potentially a divorce, custody of their children. That advocate who's helping them with everything else has to say, oh, well, for this particular issue, I have to send you to legal aid. In my community, legal aid is able to serve 7% of the people that need and qualify for its services. So very high drop-off rates at the point someone needs to be referred to legal aid. In addition, very re-traumatizing for survivors to have to go to a siloed legal service. So that is partly why community services really do want to provide legal advice to clients, but they say over and over again that they need the training to do that. They worry without the training that they won't be giving the right advice. But they do think with the right training and the permission, they have capacity. They're already spending, they think, enough time and enough relationship building with their clients that embedding legal advice in those services is possible for them. Finally, when we talk about the barriers, in general, what we're seeing is that, particularly with like LP programs in Arizona and Utah and the sandbox requirements, that the amount of education and time and training that states are setting for paraprofessionals are going to exclude the nonprofit community. If you, for example, if you require paraprofessionals to have a college degree, well, that's only 35% of the social service providers in the nonprofit sector. If you build a program that costs thousands and thousands of dollars to enroll, you're going to exclude them because 27% of social service providers earn an income below 200% of the federal poverty guidelines. Our organizations also worry about liability. We've been telling them for a long time not to give legal advice, so now we're telling them they can, and they're wondering how do they do that safely. And then also, some of them have their own ethical codes that need to be kept in mind as we build out expectations for new types of legal service providers. So this idea that, oh, now social workers will be able to give legal advice, potentially very exciting, great way to build the bench, except that social workers are potentially mandatory reporters. They also have an ethical duty to promote self-determination. Lawyers are used to saying, here's what you should do based on the facts of your case and the applicable law. Social workers, they're trained not to tell people what they should do. So those sorts of issues, I think, need to be resolved in the design of regulatory reform. And then finally, when we work with court decision makers, we were interested in knowing whether they were thinking about non-market driven innovation as they designed regulatory reform. We want to know what practical limitations they face in building non-market driven innovation into their work. And then we want to know what tools and strategies would assist them in diversifying the perspectives at the front end. So are they considering market-driven innovation? Generally, no. As efforts have emerged in Arizona and Utah, what the structures were assuming a for-profit model. So the sandbox application, as we helped nonprofits get into the sandbox, they struggled with terms like ownership and company. Those don't apply to them. The risk assessment in the sandbox assumes there's a consumer who's going to purchase something. That doesn't apply to our nonprofit advocates who are providing services for free. And then again, as I mentioned, these LP requirements are generally setting much too high of an expectation in terms of a social service provider's ability to enroll. But as we've raised these issues with Arizona and Utah decision makers, they've been very receptive to working with us and helping adapt their codes and provisions so that there is room for our nonprofit partners. In general, we look at the limitations that reg reform decision makers face, and I think I'm probably preaching to the choir here. You all are bringing your perspectives to the table, and you're doing this. This is uncharted waters, right? Like, you're trying to build something that doesn't exist in Texas, and you all have full-time jobs in addition to serving on this task force. And so there's also, I think, a capacity issue to do the work and to keep the work going. And you've been instructed to think about consumer harm, but you probably don't have any consumers at the table right now. So it's difficult to understand what level of harm consumers are willing to bear in terms of new services that are offered to them. So one of the things we recommend is include your community-based organizations now in the design and implementation of what you are building. Get their feedback now before you build out codes and provisions and expectations about what level of training, eligibility, certification, ethical requirements, discipline requirements could they sign on for? Like, where would be the middle ground in what you could tolerate from a risk standpoint and what they can tolerate in terms of a capacity standpoint? So we're the design hub on this project. We're housed in an education institution that really positioned us to be able to gather information from all of these diverse stakeholders. We think it's really important for reg reform efforts to find someone, and it doesn't have to be us, but someone who can be that neutral. As I said, I know you're short-staffed and likely feeling under-resourced. That's not a problem that's going to go away. But for our consumers that we've worked with, I think we've been a safe space for them to share their perspectives. Every project we work on, we interview lived experience experts from the field. We compensate for them for their time. We want to understand their justice needs from their perspective. And we're a trusted source for them to be able to share that information, or a trusted place for them to be able to share that information. We've been able to bring together community-based organizations that have limited capacity to do that networking on their own. And we can bring the stakeholders to the table to try to inform equitable design of regulatory reform. You mentioned there's a full report. There's the link to it. I can also drop it in the chat while we're doing Q&A. I just wanted to point out that at the end of our report is a worksheet that we built for courts and states. It was shared 2 weeks ago at the Legal Service Corporation Innovation and Technology Conference. It's really meant to be a step-by-step worksheet on how to adapt and adopt some of our recommendations from the report. So that was a fire hose of information, but I will pause there. I'll turn off my screen. I'll drop those links in the chat, and then I'm happy to take questions.
Thank you, Professor Butler. Yes. Do we have any questions for Professor Butler?
Question.
Yes, please.
So thank you very much. I thought that was most helpful. And I think you made an excellent point that we have the opportunity to learn from the experiences in other jurisdictions and other countries. And in particular, I think you noted that one reason there hasn't been much of an uptake is that some of the requirements have been particularly onerous. Linda Acevedo had made the comment about Washington State. And I think what we've learned from Washington State, it was just the regulatory requirements were just so high that there weren't that many people that were interested in getting licensed. But from the standpoint of the feedback you've gotten from these community organizations related to liability and their concern that they'd have this kind of exposure, was there discussion as to the role of insurance that
Yes, so our domestic violence advocates in Arizona are insured through the NLADA, which is the insurance provider for most of the legal aids in the United States. Our medical debt legal advocates, one nonprofit will be getting outside insurance, and the other already had an attorney on staff, and so they were able to expand their insurance coverage. But yes, that's certainly a live issue in onboarding nonprofits into the space.
And was the motivation on the part of the organization? Because my recollection is in both Arizona as well as Utah, there's no insurance requirement.
Yeah, I know that's true for Utah. That comes up a lot in Utah. I don't know if it's true in Arizona, but yes, I think in general, despite the fact that we haven't had any complaints from consumers on these projects, I think that yes, it has been organization driven.
Well, we really commend you on the work you're doing. So thank you.
Thank you.
Judge Livingston.
Do you have suggestions? First, thank you. But do you have suggestions on how we might identify and choose the right community-based organization or organizations to participate in? How many?
That's a really good question. I would suggest, have you done a justice needs study in Texas?
Not lately, as I understand it.
So that's a community needs study or a justice needs study can be a great way to start in terms of identifying what are the highest problem spaces, the highest volume problem spaces that are likely to be civil legal system involved in Arizona and Utah. It's family law, housing, and debt collection. So if you have an idea of, and then you obviously also need to do the inquiry of like, are those consumers in those spaces able to pay for services? Because I think what we see is that in family law, yes, some of them perhaps could. And I think that's why the paraprofessional effort is potentially more successful for family law litigants. But in debt collection and eviction, really by definition, that's a consumer base that cannot pay for legal help. And so then locating organizations in your area or in your state that are likely to interface with people experiencing those issues. Housing, I think, is a great example of nonprofit sector is going to interface with tenants before legal system, because when people start struggling to pay rent, the rent eats first, they turn to social services for food assistance and other benefits. So those are the people in your community that are most likely to identify a tenant who's struggling with housing instability. The legal system tends to only get involved when that person is handed their eviction notice. At that point, the tenant is probably not in a great problem-solving space, and time is very short. So I would start by thinking about, what service areas do you think you might be targeting with what we call the community justice worker model? And then who are your community-based organizations in that space? I think in terms of numbers, I don't think there's one magic number. Enough to get a diversity of perspectives, a diversity of perspectives informed by the demographics of your state. If you have organizations that are particularly targeting, particular racial minorities or other groups that you want to make sure have a seat at the table, I would keep that in mind.
Thank you.
It's been so helpful. Yes.
I have a question. With the community organizations that may have the will to expand in providing legal services, a lot of them don't have money to expand. So is there seed money or other funding that would enable them to do that?
So yes, our pilots have been grant funded. We're using an upskilling model. So it's fairly cost effective because we're training people they already have on staff and are paying for already. So the cost is really just to add the benefit of that additional training and education to existing staff. Our curricula are modular and online. They take 60 to 80 hours. So far, we've offered them for free to organizations that have been a part of our grant-funded projects. So we actually have been able to compensate the organizations we work with through grant funding for the time that it takes their staff, for the cost of their insurance and things like that. It'll be interesting to see as we approach scalability, how organizations can do that, because obviously I won't be able to grant fund every organization in Arizona and Utah that wants to have that upskilling work happen.
Are there any other questions?
I have just one question, because I've heard from a lot of people concerned about consumer harm when addressing whether this should be done in Texas. And I know that data is being collected. You've said, no evidence of consumer harm. And so can you give us a better sense for how that data is collected and how soon it becomes available? Because I know that's something we're going to get questions about as we engage in this effort.
So I think it depends on the pathway that you use to include the nonprofit sector in new types of legal services. In Arizona, our work has been authorized by administrative order of the Arizona Supreme Court. We are doing the monitoring and evaluation and reporting to the court. The only project that has that evaluation live right now is the DV Advocates Project in Arizona. And again, so far, no consumer complaints. In Utah, we're in the sandbox. So we're going to be reporting the consumer harm just like every other sandbox participant on the schedule that the sandbox sets. I do think it's important to keep in mind when we talk about services for the low income community that the baseline for that community is no help at all. And so when we look at the risk of consumer harm or the benefits to consumers, we need to remember that the balance is giving them a legal advocate, someone who's authorized through regulatory reform, is that potentially better and more helpful and less harmful than that consumer navigating the system alone. So the comparison is not, would they be better off with an attorney than an advocate? Because in general, it's a population that isn't adequately being served by lawyers.
Thank you very much.
Thanks for this presentation. I have a question about what the services in the housing and debt areas might look like for the low income population if we're talking about an intervention before something's happening in court. So as lawyers, I think we all can imagine that once somebody is taking action to evict a tenant or collect a debt, there are often legal defenses. You can say it's being done in violation of a statute. You failed to present the proper proof. But can you explain what the services might look like if there's an intervention before it gets to that point?
Sure. So all of our interventions are designed with and within community, and that community includes attorneys and judges and attorneys on both sides, plaintiff and defense counsel. And so we work a lot with the attorneys to understand what are the potential defenses if this did end up being court involved, and how do we train advocates to watch for those? But I think the hope with debt collection and eviction specifically is that part of it is the educating the potential defendant about the risk of the problem becoming civil justice involved. Both eviction and debt collection, once a case goes to court, the odds of succeeding are very, very low. And once you have an eviction judgment or a debt collection judgment, now you have all of these collateral consequences like wage garnishment. And so trying to work with people before they're in crisis to understand we don't want this to become a court action. Let's get you connected with rental assistance. Let's get you connected with financial counseling. Let me contact your creditor or your landlord and let them know we're working on this, and be an advocate voice earlier upstream. We also hear often from consumers that they don't feel empowered to speak up or to advocate for themselves at that stage, and they don't feel equipped to do it. And so having a community-based advocate who can manage some of that and proactively engage and try to problem solve, we also anticipate will be helpful.
All right. Are there any other questions before we break for lunch and let Professor Butler go? Thank you so much, Professor Butler. We really appreciate your time and your expertise and also just your passion. Thank you.
Thank you for having me.
Okay, working group members, both in person and online. I hope food is outside. I'm guessing it is. Okay. Okay, it's on this way. Okay. We're gonna. Yeah, I think it's in the lobby, right?
There's food nearby.
There's food nearby.
Maybe over there. The originally was going to be there, but I think it might be switched.
For those online, we're planning on really just getting some lunch and coming back and having some minor conversation. But our next speaker is slotted for 1 p.m., which is just 30 minutes away. Okay, we'll see y'all back at 1. And it looks like we're getting the folks online back going as well. And I am going to turn it over to Katie to introduce our next speaker.
All right. So next we have Nicole Nelson, and she's the Executive Director of the Alaska Legal Services Corporation. So We've already heard a lot about Alaska's programs being mentioned by our previous presenters, but now we actually get to talk to Nicole. So this is super exciting. So Alaska Legal Services Corporation is Alaska's only statewide provider of free legal services. And Nicole has really been an innovator in providing legal services, given some of the challenges that Alaska faces. The Legal Services Corporation developed a medical legal partnership model that serves remote Indigenous communities. This was recognized as one of the 5 most promising practices worldwide for increasing access to justice at the 2019 World Justice Forum. And then recognizing that the need for civil legal services was far greater than legal aid attorneys could provide, in 2019, she developed the Community Justice Worker Program. It began as a new approach to solving the justice gap by empowering legal advocates in rural Alaska communities to provide certain legal services with training through legal aid and supervision through legal aid. This program is the first of its kind in the nation, and this is something I think that would be really interesting for us to hear more about as we embark on our study. So Nicole, thank you so much for being here. And if you could just kind of let us know a little bit more.
Hi, thank you all for having me. I'm Nicole Nelson, and folks have said, I'm the executive director of Alaska Legal Services, and I'm not sure if it's most helpful for this convening to, I can give you some background about our community justice worker program, and I'm also happy to answer questions that you may have. But I don't know, I guess I want to be most useful to you. One thing I could do, if the group is interested, is just sort of give an overview of how we got to the place that we're in, and why we and talk about our community, why we developed the community justice worker program, and what we think we're going to do with it as we move forward. I have a little bit of a slideshow if you'd like, or I can just answer questions. I want to be most useful to you, so tell me what your preference is.
We would love the slideshow.
We're
in information gathering mode this morning or afternoon. So
okay, great. Fantastic. Well, I will let me just pull up my slide deck here, and let's see if I can share it with you.
Members into this joining us online. To the extent a presenter did include a PowerPoint, we will try to get those distributed when the recording of this is posted online.
If you'll hold on for just 1 second too, there's somebody knocking on my door here, and I apologize. So just 1 second.
It's Amazon.
Right.
Or the Girl Scouts.
That's beautiful, right?
Oh,
All right, sorry about that. I think folks that were knocking on the door were just the folks that you may have heard from earlier today, but that was Becky Sandifer. So I'm in Arizona at the at a convening, and so okay, so I was just, let's see, I have shared my screen. Can you all see that?
yes,
we can.
Yes. Okay, great. So calling my presentation, or usually my slideshow, is looking for justice in all the wrong places. And before I get started, I just want to give you a bit of background about how we undertook sort of this progression of getting to the community justice worker, module. So our training program. So first off, a few years ago, I was working with one of my colleagues, Liz Medicine Crow, who is the president of the First Alaskans Institute. And with working with her, I posed this question. I said, Liz, what do we miss when we fail to when we only include lawyer voices in our quest for justice? And what Liz said to me, which I'll share with you in just a few minutes, floored me. And it was unexpected and really changed my mind about a lot of things. And in order to understand this too, you should know a bit about me. I have been practicing as a legal aid attorney for 25 years. So I've been doing this since I got out of law school, and I have been seeking to address the access to justice gap in Alaska for that entire time. Now, a little bit of background about Alaska. Too. For those of you who haven't had the good fortune of coming to Alaska, we are a beautiful state that has amazing mountains and glaciers. We have beautiful northern lights, and we are also enormous. So our land is as big as the next 3 states combined. That includes our what we lovingly call our little sister Texas. So if you can Texas, Montana, and California combined, Alaska covers that land space. And we have big cities like the one Anchorage, well, what we call big cities, like for instance, the one that I live in Anchorage, and this is a picture of it. And about half of the population lives in Anchorage, so about 300,000 people live there. And then the other, we have many other communities that are spread, dotted across this vast expanse that can range from about 30 people in a village to maybe 600. And so and we also happen to be the most Indigenous state in the Union. We are proudly home to 229 of our nation's tribes. And we are grateful every day for the unique way in which our tribal communities influence our way of living. Another thing to know about Alaska is that most of our communities are not located on the road system. If you look at this map, the road system is where the white lines are. And all of those other communities, about 90% of those are not connected by any road. And along those road systems, most of the justice infrastructure and state infrastructure is located along the road system. So, you can tell that leaves out many communities where they wouldn't have the infrastructure that one would expect in the United States. So for instance, there aren't courts there aren't police oftentimes, and many of our communities lack access to basic services such as running water. And so, like Alaska, and like every other community that a legal aid community or legal community that I know of, we face an enormous justice gap. And I think it's a little bit funny. I'm sure you all are well familiar with the justice gap. I like to call it a justice crisis. I think we've moved past the point of it being a gap. In Alaska, just like the lower 48, the estimates are that about 92% of people who would need it are not able to access the civil legal help that they would need. So again, we have this enormous gap or crisis or a crevasse, as we might call it up in my parts. And like every other legal aid provider that I have ever met, we are drinking from a fire hose every single day, no matter how hard we try. There are more people that come to our doors than we are ever able to serve. We are turning away one person for everyone that comes to us. And also, that's not even including the others, an estimated 80% of those who have the needs that aren't even making it to our doors for reasons related to distance, geography, and other access issues. So we are drinking from a fire hose. And it's heartbreaking. Nobody went into legal aid because they wanted to turn people away. And yet that's what we spend the majority of our time doing. And so it's with this background that we decided that we really needed to do something to turn the curve. And this sort of to turn the curve. And this sort of relates back to the question that I asked Liz Medicine Crow when we first started talking about how we might turn the curve and make a difference in Alaska's justice gap a few years ago. What she said to me at that point, when I said, in response to my question, what do we miss when we are only including lawyer voices in our quest to make justice accessible to everybody? She said, you're missing the whole thing. She didn't say we were only nibbling around the edges, that we were on track. She said that we were missing the entire point of the exercise, because by excluding those who are closest to the problem in the solutions, we were missing justice altogether. And this sat with me a lot. Over the course of the next 2 years, we started, in addition to embedding, building medical legal partnerships where we were embedding legal trained staff in the tribally operated healthcare system. We also we learned about the way that the healthcare system had modeled, had been stratifying the practice of medicine and had built community-based community health aides, behavioral health aides, and dental health therapists that were all recruited and trained within local communities to provide certain level of healthcare service or dental health service. And that these embedded, culturally connected workers were really making a difference in improving health outcomes in our far remote regions, and also not only in improving health outcomes, they were also seeing an increase in preventive health outcomes as well. And so we, at that point, thought, well, why is there not a justice analog to a community health aide? Why is there not a justice analog to a behavioral health aide or a dental health therapist? And we set about building training modules and distance learning. We engaged distance learning professionals to help us build out the training that would help us develop a network of community justice workers. And we first started building out this network about 5 years ago in areas that would not run afoul in Alaska of the unauthorized practice of law prohibitions. So these are areas where we were helping people draw down public benefits, like when they were having difficulty with SNAP, which used to be known as food stamps, unemployment benefit compensation, will drafting, something that's unique to our area, the Indian Child Welfare Act, where in work that is commonplace in Alaska, child in need of aid cases, tribes have the right to have a representative of the tribe engage in state court proceedings. These do not need to be lawyers. And so we developed training programs and curriculum with distance learning professionals at a local university and in conjunction with the healthcare system to provide support and training to what we were calling community justice workers. And over the course of the several years, we had our training program went live in 2019, and we have since then recruited over 100 different community justice workers that have enrolled and are progressing through our training modules. They are supervised by attorneys at Alaska Legal Services. And to date, they have been 100% successful in the limited scope cases that they have taken on. So we're very proud of that, and have basically extended our numbers as a legal aid organization. Again, we have a total of 60 staff with our trained up community justice workers have more than doubled that. And they are located in 40 different communities, many of which we don't have a local office. So flash forward to this September, we asked our Bar Association in conjunction with the Alaska Supreme Court for a waiver that would allow community justice workers who have been properly trained and are supervised by Alaska Legal Services for us to upskill them in particular areas where they might would run afoul of the unauthorized practice of law prohibitions if we did not have a waiver in place. And our Bar Association, the Board of Governors unanimously approved of the waiver, and our Supreme Court passed it in just December. So we are now at the point of developing, in conjunction with national access to justice researchers, the protocols and training protocols that will allow us to upskill community justice workers so that they might be able to engage in a limited scope practice of law. And so we are hoping in this way that we might be able to turn the curve and change the way that justice is delivered in our state so that it is not delivered by professionals who are far off and removed from the community. to address the justice gap. And when I think about this, one of the questions that sometimes come up, people will ask me, well, aren't you worried about, that folks are going to get a second-class justice? And I am not. And the reason I'm not is for two reasons. First, I hearken back to what Liz Medicine Crow told me when we first embarked on this a long time ago, that the common perception from folks who are not lawyers or in this community is that the justice they are currently receiving is far removed from them, and it does not feel like a just system to them. And so if we want it to be people-centered, we need to include people who are closest to the problems in coming up with a solution. And I think one of the things that we need to maybe get used to as legal aid providers and as lawyers in general, that is an understanding that what folks are looking from the justice system are sort of right-sized solutions that are easily accessible, that are timely in nature, and that might not look like what we as lawyers might come up with. And so again, when I look back at the system and when our understanding that 92% of people are not able to get what they need from the system that we currently have, I'm not really afraid of trying something new, because I think we have to. I think part of it is a realization that the work that we are currently doing, the justice system as it currently is not meeting the needs of those who would need it most. And as a legal aid lawyer who's been doing this for 25 years, I want to make a difference, and I want to make sure that the justice is accessible for all, not just those who would, not just those who could afford an attorney. And so there was a local artist at our museum in Anchorage that had, over the course of the pandemic, this picture up on the spread across the museum, and it showed a bunch of hands putting together pieces of rocks that had been shattered. And the idea was a meditation that we could build something that looked different, and that although it might not be the same as what we currently have, it might be beautiful. And I think that there's so much potential for us to reimagine our justice system in a different way that feels more responsive to those who need it most. And if we include those folks in the design of those systems, I think that we might end up with something, we are likely to end up with something that's more workable than the one that we have now for most people. And I also teach us justice folks who are involved in the justice system a little something about what justice really feels like to those who are seeking justice, and not those of us who are in the business of justice. So that is, I'm going to stop sharing my screen, and I'm happy to answer any questions you might have.
This is Massengale.
Thank you, Nicole, for that presentation, and it's very exciting to hear about what you're doing in Alaska. Since you are so close to it, and you've got this project that's going, and you've gotten your bar and your court engaged, it would be helpful to me, and I think probably some others, if you could just share some concrete examples of things that the community justice workers are able to do with the benefit of these waivers that they otherwise would not be able to do.
Sure. So I'm going to differentiate between two things that our community justice workers are able to do currently, and then those which we hope that they will be able to do with the waiver in place. So as I mentioned before, we've been building the training network for the community justice workers for the last 5 years. And so currently, the community justice workers are able to represent people in administrative hearings. They are able to draft wills, which is a big need in our community for folks to avoid the fractionalization of Alaska Native land. So that is one need. They perform tasks related to avoiding debt collection. So that's sending letters to creditors and helping people with to avoid the way that you can avoid a default judgment in a debt collection case. They are also able to provide our ICWA workers. We have training for our community justice workers who then represent their tribes in state court proceedings in Indian Child Welfare Act cases. And also they are able to give advice in domestic violence protective order cases. With the waiver in place, we hope that then people will be able to provide representation in domestic violence protective order cases. And we hope to expand the scope of practice too, so that community justice workers may be able to help provide representation in landlord-tenant proceedings.
And right now, how many trainees are able to go to the communities that are not on the roads?
I'm sorry, I had a hard time hearing the first part of that question.
How many of the trainees are able to go to the areas that are more remote, that aren't on the traffic?
Yeah, so most of the trainees are actually embedded in those communities to begin with. So they took the training programs. Our training center is online on demand and it's asynchronous. So it can be done at a person's own pace. So we recruited people who are from the communities in which they are serving people. But also because of, the technology that allows us right now to zoom in, people could provide assistance to folks in other communities as well. But we designed our program with the intent that we would be training folks from the communities in which they are able to serve, which really helps us. Texas is a real big state, so I imagine you have large rural areas where you don't have a lot of lawyers, right? And most of the lawyers in Alaska are along the road system. So we specifically are recruiting and supporting community justice workers who are in our most remote communities.
Are the community justice workers already affiliated with some sort of organization or agency? And if so, what sorts of organizations are they affiliated with?
Yes, they are. That's a really good question. So our community justice workers, while they are coming in as volunteers to our organization to help with our help address the justice needs of Alaska Legal Services clients, they're actually affiliated most often with nonprofit social service agencies. So domestic violence shelters, in many of our remote places, the social service providers are tribal social service providers. And then we also have, some folks who Alaska doesn't have a law school. So we've got folks in the lower 48 or law students that have taken some of the courses and are also able to help in certain circumstances. But more often than not, most of the workers are, or they are also embedded in the healthcare system. I'm sorry. So let me step back to that too.
Nicole, how many people have you got currently doing this?
So as community justice workers,
yes.
we have recruited over 200 community justice workers. About 100 of those have completed the necessary training programs and have helped assist with individual cases.
Do you have a sense on an annual basis how many people they represent or cases they close?
Yeah, so right now we have had 75. So of the properly skilled and trained community justice workers, 78 cases have been placed with those folks. And we have outcomes for all of those cases. Again, as I mentioned, they're 100% successful to date. And again, it's not, we are really, when we're thinking about the work that the community justice workers could engage in, it's not the full practice of law. They're limited scope practitioners, right? So we are looking at sort of providing right-sized solutions for people, for the legal problems that they have, not all of which require court representation. Some of it just requires, help going through, help moving through various bureaucratic systems and understanding those, and then providing some advice in that area. I think there's a question here. What areas are the community justice workers engaged in? Great. So right now there are debt avoidance, so anti-debt collection work, debt avoidance, Indian child welfare act cases, so that would be child in need of aid cases, domestic violence, and benefits. So unemployment compensation and SNAP, which is formerly known as food stamps, and other administrative proceedings.
What type of support and supervision do you provide to your community justice workers after they start handling cases?
Sure. So we provide them with supervision, and so all the cases. So when each case is placed with a community justice worker, they're assigned a supervising attorney that works with Alaska Legal Services. Some of those are pro bono attorneys, so they have an attorney mentor or supervisor that works with them as they go through their case. And then also we have the training modules that they take as a part of their coursework as they're learning to become community justice workers. And so these modules are hosted at a local university, Alaska Pacific University, and then were designed with distance learning professionals to speak to people who aren't lawyers. They're written at an 8th grade education level and there are sort of tests and hands-on work assignments that relate to the specific tasks that they would be asked to do in real life. And so we have the training modules, and then we have an attorney supervisor or mentor for each case that is placed so they can go back and ask questions to and help resolve the issue.
I have one question. Is there a particular data point that drove the decision to have these individuals supervised by attorneys as opposed to unsupervised?
Well, no. I mean, I guess one of the things that we'll be looking as we grow is, I think it was a comfort level, right? So we started at a very practical level just to build out. And I guess what I would say when we were trying to figure out our sort of guideposts as we were moving forward and trying to think how we were going to make a change to the system that currently was, we didn't want to get bogged down in sort of letting, the perfect be the enemy of the good. And also we wanted to make use of what we currently had and be willing to sort of go where the evidence takes us, right? And so, so as we first started designing the community justice worker training modules, in order to avoid running afoul of the unauthorized practice of law issues with our bar association, we needed to have that attorney supervision. And so we started the program doing that. And then we committed to gathering the data and the evidence that would show their effectiveness, with the hope that we could go back and do something different in the future. Right. And so so again, there wasn't one data point other than we wanted to look at what was doable within the current system and how we could expand that and agree to sort of collect the outcome data and move forward to expand practice. As I said, right now, 100% of the community justice workers' cases that they've taken on have been effective, and we're collecting that data. We'll report back to our Supreme Court as we move forward and as we work to develop a training structure that will provide the necessary training, and we hope supervision or whatever is the right size supervision that comes out of that to our Supreme Court in the future.
Just as a point of clarification, so the current workers are supervised if the Alaska Supreme Court approves the waiver letters. Will those workers still remain supervised by an attorney?
They will remain supervised by Alaska Legal Services, so depending on the scope of practice. So the waiver that was approved by the Supreme Court in December allows us to put forward a particular candidate for the waiver, to define what their scope of practice is, to talk about what their supervision structure will be, and also what training they have received. and to report back on that. So again, it's a very flexible model. And so we envision, depending on the supervision is going to change depending on what the individual that's put forward and what their supervision needs would be. So for instance, you can imagine I have folks who have been, in one of our communities, a person who's been working for Alaska Legal Services in that community for 20 something years. She's been representing people in administrative hearings during that time, which is allowed without the scope of waiver. Should she choose to expand her practice and go into, like, for instance, doing domestic violence protective orders on behalf of ALSC clients, we could put her forward for a waiver, suggesting that she would need the supervision of an attorney as she completes a certain number of hearings before, and then we would come back after that certain period of time, perhaps with reports from the local judge, and also, having collected the data on her outcomes, and that at that point we could come forward and say, it looks like she's co-chaired with an attorney or has been supervised with an attorney for this amount of time and appears to be doing well. She's, by all measures is doing well. Do we need to have that same level of supervision in place? Could she, perhaps now it's time to move forward and she could just be doing that practice on her own without that same level of supervision?
And it sounded like, Nicole, from what you said as well, that with the waiver, there's more opportunities to do that sort of in-court representation, right?
Exactly. That is correct. We have not put someone forward yet for in-court representation. We asked for the waiver first so that we knew that there was a pathway possible. And now we are working with, we're working with our educational and just our, education experts to help us develop what those training programs might look like. But we really wanted to we thought it was important to have the waiver in place before building out those programs so that we knew that it was possible, that we weren't going to get shut down.
How did legal services receive additional funding for the trainings and the development of the trainings? And how does that continue going forward if you did?
Sure. So we developed the trainings in conjunction with our community partners, the Alaska Native Tribal Health Consortium and Alaska Pacific University. And those were our partnerships as part of our medical legal partnership. They helped us with those trainings pro bono for some piece of it. And we've been able to find other funding. The Legal Services Corporation also, through our Pro Bono Innovation Fund grants, gave us additional funds to support those trainings. And we have part of our sustainability plan is reviewing those trainings and making sure they are, they continue to be accurate and current. So one thing, we didn't get specifically additional funding. Like for instance, there's not a set aside funding for the work that we're doing, but I do think that as a provider of legal aid, rethinking about how this could amplify our work makes me rethink about how I allocate the current resources that I have. If I think I can expand my staff by almost doubling it at this point by providing training and proper training and supervision to a network of folks who are already working in other organizations and are doing similar work, then that makes sense to me that I should be investing more of my core dollars towards that end. Also, I think that there has been a large investment also from our community partners because they see how these health harming legal needs are really, and they're not, these are outside the world of lawyers. These are people problems that are impacting, it's homelessness, it's domestic violence, it's inability to maintain food or income. And these are just problems that every community is facing, and your other social service providers and the communities themselves are struggling to figure out a way to address those. And so they want to invest in a model that will work. And what's really nice about it is they're really hungry to have Lawyers come in to help people understand what their rights and responsibilities are in these areas and how you might be able to use the laws that are already in place to address some of these problems. So, I think our community partners have been really hungry to partner with us and invest some of their resources in this work.
Judge Livingston.
Of the 100 or so that have already been through the training, are there some number that are not associated with an existing social service agency or legal aid that are what I'll call on their own in their communities? And are you monitoring, is there a standard fee schedule, for example, for a task? If it's this kind of a problem, you would expect them to charge this rate. How does the fee structure work? How are they paid and compensated for the work they're doing for those that are not associated with a social service agency or a legal aid program?
Right. Okay. So right now, one thing's to be clear, nobody is charging for the services that they would be providing. Our community justice workers do not charge for their services. They may be employed by another social service provider, and there may be folks that are just volunteering their time, but they are not charging clients for the services. And that's written into the rule too. The waiver that we asked the Supreme Court for applies specifically to Alaska Legal Services clients. So we have to approve the client, assure that they are, aren't able to can't afford legal help in another context, and then we make the placement. And people are not charging, the community justice workers are not charging for their services.
So are all of these individuals that are being assisted by the community workers, justice workers, are they coming through your Alaska Legal Aid intake system?
Yes.
Okay.
They're just people that you don't have the capacity to serve without this program.
Absolutely. Right. Well, and it is also helping us too, which is interesting, because we're always short staffed like every other legal aid, and we have to turn folks away. By having this pool of community justice workers who are able to help carve off certain sort of lower level legal skill areas, it's allowed me to readjust to put my attorneys on, addressing higher level skills like representation in court instead of helping with these other areas, which are really important in making sure that people are, can get food for themselves, that they are, that they aren't losing their housing, they're not being, like sort of these other areas that are really important and would meet our prioritization task list, but don't require necessarily high level legal skills. So with the community justice workers are able to provide that representation, it allows me to reorder where our attorneys are going and have them more focused on sort of the higher skill level lawyering than I otherwise would.
I hate to ask this question, but I'm going to ask it. Since we're here, a lot of us are lawyers. Does your malpractice insurance cover the community justice workers?
Yes, our community justice workers, our malpractice insurance covers all of legal service, Alaska Legal Services clients, no matter how that service is provided. So as long as they're our client, they're covered by malpractice insurance.
Great. That's great.
Nicole, thank you so much for your time. I know we've run over here with these questions, and so we really appreciate you staying a little bit longer so we could get questions answered. And there's a chat question, but
okay.
There's a follow-up from.
Okay, are they included in Alaska Legal Services for reporting purposes? Yes, the cases are included as Alaska Legal Services cases for our reporting. And does ALSC fund the community justice work? If so, what kind of funds? So we fund the training programs and the attorney supervision, whether that's through us or sometimes it's a pro bono attorney. But again, our pro bono attorneys have some. We have a pro bono program, which receives some support from Alaska Legal Services to hold up sort of the infrastructure. So, and we use a wide variety of funds that I think are probably pretty common to most legal aid providers, whether that's LSC funds, our state appropriation funds. We also receive funding from every community in which we have a local office. We have 12 of those. Those can be used to help support the work. And we also are hoping, and we're still working to build out this program, but I think using workforce development funds to support apprenticeships. So if we had community justice workers apprenticing in our local offices, we could use workforce development funds for that purpose. Well, thank you so much for inviting me to come. I appreciate it.
Thank you. Okay. So Paul and Maria, how soon can you start?
Already got it. And a lot of these things, I mean, how many paralegals do you think we have?
I wouldn't hazard a guess.
We have 70. And Maria and Robert have, you know, similar numbers to that. And a lot of the work they do is that. Furthermore, all our boards are required to have 1/3 eligible clients. And we have client groups that don't really represent people, but they go out and they do outreach and community education. This lady needs to be applauded for what she's done. She's sort of repackaged something that legal aid programs do. We could do that. We could sure do. AmeriCorps workers. There are a lot of legal aid programs that bring in dozens of AmeriCorps workers. We could do that too.
Wow.
Legal Corps is what they call it in California. Legal Corps, yeah. It's modeled after the AmeriCorps.
That's fantastic.
They employ like 100 of them or so in the, more than 100 in the LA County court system alone, just in LA County, over 100.
We ought to hear more about that model too. That's interesting.
Yeah.
The big thing about doing those things is you have to have a tremendously creative and talented administrative staff to run the paperwork for it, because it's massive.
And it's, yeah.
Well, that may be part of what we can look at is how to streamline some of that.
It's impressive. It really
Impressive.
is.
Well, the next item on the agenda is to just talk a little bit about the structure. I'm having a little bump here. About the subgroup structure. And so Kenan, if I could turn that over to you to lead us off on the structure.
You bet.
Thank you.
You bet.
Congratulations.
So there's been a lot of reference to the letter from Justice Busme about what we're doing here. And as all of you probably have ascertained from reading that letter, there are several different components of the task. And so what we did at the co-chair level is think about how to break this up among us into subcommittees. And we also recognize, as Lisa mentioned earlier, that we need a group here that's manageable in size to make decisions, but we can have more people working boots on the ground at the subcommittee level than we have around the table at the working group level. And so the way we've done this is broken into 3 different subcommittees. I'm starting here on the program only because mine has been referred to in Lucian as subcommittee 1. And so this is the subcommittee that's looking at analysis of if we have these paraprofessionals licensed and qualified to provide limited legal services directly to low-income Texans, what would be the potential limits on the type of work that could be done in the areas of law in which that work would be done? And also, what are the potential rule and, as we think about it, statutory revisions that would be needed to authorize and define procedures for the limited practice by these individuals? So that's just generally what this subcommittee would focus on. Before I go further, I'll say that we recognize that these are all kind of interrelated. So I suspect that as we're doing this work, the subcommittees will work together and perhaps we'll meet together as appropriate along the way. But that's subcommittee 1. And I think I'll just stop there instead of getting into the weeds in terms of who we've been considering for participation. But I will tell you a whole lot of thought has gone into who might be on these particular subcommittees, including who from the working group might be willing to serve. And some of you have already been asked about willingness to serve, but beyond that, we've given thought about who should be represented here. So I'll stop there and turn it over to Lisa to address the next subcommittee.
Okay, so I'm what we're going to refer to as the licensing subcommittee. So if you think about, what that means, it really is kind of the nuts and bolts. If the court elected to license or somehow certify non-lawyer paraprofessionals, what would that look like? What would the application process look like? What would the disciplinary process look like? What would the ongoing CLE, like how would we make sure that they stay current the way that lawyers do? And so I'm really going to be looking at the nuts and bolts, including, are we going to have ethical rules adopted by, that they would need to follow, or handling conflicts and things like that. So, whether that's inserted into the current system for regulation of lawyers, or if that's separately regulated, as we've heard some of our speakers talk about today. I don't know. That's what our subcommittee will be looking at. So you can imagine that, without getting into too much detail about who would be on my subcommittee that's not in this room currently, we would want to hear from people who are in attorney disciplinary process. We would want individuals from like the Board of Law Examiners who there is actually a paralegal.
Would we though?
No, I don't know.
No, I mean that seriously. I was struck by what you said, the way that lawyers are. I think if we're going to be committed to an open mind, we have to leave open the possibility that it will look nothing like the way that lawyers look. And so I just pause there to say, it might look like what we do for lawyers, but it might not.
100%.
And so
I agree with you totally.
Let's not make it too top heavy with people who are going to say, do for them what we do for us. What we probably need to be sure we include are people who say, it really shouldn't look anything like that. It should look like something completely new and different. Or maybe it should have just some of that, but some of this other stuff, or none of that and a lot more of this. So I'm just asking us to really, really keep an open mind so that what we don't do is just replicate for some other group that we're calling a subgroup, so to speak, right? Because to me, that dooms it to disaster already. So let's really be open-minded, and that means being thoughtful about how we populate them and with whom, and who really are stakeholders, not just the counterpart in the legal world.
For sure. And if you do have any suggestions, that's one of the things we're going to talk about later too. Not just, of course, individuals, but just categories of people that you think should be at the table for each of these subcommittees. We would love that input. We've thought a lot about it as leadership, but we certainly have certainly overlooked somebody or some type of person, some stakeholder that we would want at the table. We've probably overlooked them. So I think I'll let you do subcommittee 3 then.
Sure. So the third subcommittee is going to be looking at this concept of modifications to rules to potentially allow non-attorneys to have an ownership or economic interest in an entity that provides legal services. We're specifically focused on providing legal services to low-income Texans. We've been specifically admonished to keep an eye on one of the objectives of Rule 5.4, which is preserving the professional independence of lawyers. So the way we've kind of broken down for now, the elements of studying this question as the court has defined it, we want to look at how Rule 5.4 is being implemented nationwide. There's been some robust debate about that, and as we've heard today, it's been outright appealed in Arizona. So we want to study what's happening nationally with Rule 5.4. We want to investigate some of the kinds of things we've been hearing about today, the opportunities that may that may exist for expanding access to justice by modifying Rule 5.4's prohibition on non-lawyer ownership of firms. So we really want to get a good handle on what the experience in the jurisdictions where this is being explored, what that has been, and what else can we imagine, especially based on unique needs in Texas, what opportunities may be presented by a change of this rule. We're also going to be thinking about appropriate need-based limits on the legal practice areas that would be affected. We're not, I think it is not in the scope of what we've been asked to study, considering a just, broad-based total elimination of this rule, outside the scope of improving delivery of legal services for low-income Texans. So as part of that, we need to consider what the appropriate limits would be. And then finally, just sort of procedurally, to the extent that the court might adopt these changes, would we want to recommend that they be phased in through a pilot program or a regulatory sandbox like Utah is doing? So these are the kind of questions that we're going to be studying. As Kenan and Lisa have alluded to, we've given thought to sort of the types of people, meaning sort of the types of experience that we'd like represented in the subcommittee. One part of that is going to be certainly potentially affected practice areas. We want to understand their perspective about what the opportunities may be and the impact on that practice area may be. And also, I think some perspective on the reason for having a rule like 5.4 and sort of having a full understanding of what the implications of modifying that would be. I think this goes for all three of our subcommittees. We have already talked to some of the people in this room and some people outside this room about potentially helping us on these subcommittees. But now that we have the benefit of all the people in this room being in this meeting today, knowing what the subcommittees are going to be working on, we are, I think, really interested in people's specific suggestions about, either particular individuals or categories of individuals that would be particularly helpful in these groups, so we're not overlooking anybody. And so whether you want to volunteer yourself, suggest a person, or make sure that we're thinking about a category of person, that input would be really welcome by all of us.
Yeah, and I'll tack on to something that Justice Massengale said and something that others have keyed in on, and that is what areas of law do we focus on, right? Because in some of the other states, you see that it's 1 to 3 areas of law that they start with, and how do they pick them? I think that part of the method is looking to see where do we have the highest number of self-represented litigants. And family law stands out among the types of areas. Some other common ones, landlord, tenant, and probate. And so you might be getting a feel for why some of you are here. And so I think one thing that would be particularly useful in this conversation is to start thinking about that and providing suggestions in terms of the areas of law, because that will certainly shape the composition of the subcommittees and the content of the conversation.
One thing I'll just add to what the co-chairs have said, and I'm very appreciative of their work putting together the framework for these subcommittees to kind of break this big issue up into more manageable pieces. Some of the things that we heard about today, I think we'll need to think about how they fit into the various committees, because, for example, entity level regulation rather than lawyer-based regulation, I'm not sure if that fits under Justice Massengale's committee or if it overlaps all three. But there are, as Lucy and Becky were talking about, some of the things that they're looking at in Utah and Arizona don't sort of perfectly line up with. Some of them don't have anything to do with 5.4 repeal, but have more to do with entity-based regulation and broadening the definition of practice of law, the authorized practice of law. And some of that goes more towards the paraprofessionals that we may want to license, but some of it may go to the ownership structure piece as well. So I heard a lot of new and interesting ideas today from our speakers, and I've been thinking about this a while. So anyway, I think, well, and we welcome everybody's input on, which of the subcommittees should have some of these ideas as part of their structure. And I wanted to emphasize one other thing that Michael said, which is we'd love for as many of you to be engaged on the subcommittees as would like to. So please let the co-chairs know your individual preferences on which subcommittee you think you would most like to participate in. And as they said as well, anybody that you think would be helpful, we're going to want to be sure we've got a good cross section, not only from the legal profession, but also, as we've heard today, it's important to have consumers involved in this as well. And so we're going to want to get their input at the subcommittee level. And there will be a process for going out to the bar and to the community to gather input more generally to be sure that we're well informed about the needs and the concerns.
One of the things that kind of struck me about their, I've listened to Nicole's presentation before, and one of the things that struck me about what she was able to do, and especially in Alaska, is that she really looked at what already existed. Like, what were the partners that existed, not in the main cities, but in those really rural areas. And so I think Texas is big, but there are always some people in those very rural areas that are already there helping people. And when we think about like partnering with those folks, we often think about libraries and, domestic violence shelters and stuff like that, but those, they don't necessarily exist in some of these more rural places. So what are the things that do exist that we could partner with that would be relevant for cities and those rural areas alike? And I think, the providers already do so much outreach. You guys would probably know the best about who those folks are, and then try to get those folks involved.
Well, we'll open it up to, first of all, let me ask you, Katie, do you have anything else to say about, just sort of structurally and everything, what we were talking about?
No, I think you guys have covered it. And I think, as with everything, as things start to grow, we'll figure out the scope a bit more and where we're going. But I think this has been very exciting. It's been very exciting to hear everyone's questions for these speakers. So.
Well, we just want to open it up to, I'm sorry. Yes.
I just was going to have this question because ABA Days is a few days away and we're going to be going to Washington, and it's a question in my mind now, hearing what we've heard today, is we're back to underfunding legal services, that more resources be put into legal services to support some of this wonderful work. But that's not I'm not sure that's within our purview. And, but if these are going to be people in our state, and sounds like might like to have some of them. So should we have a piece of this that relates to the role of legal services, even though it's a federal entity, because some of their people may be doing exactly what we want people to do.
I think it'd be great to hear from Paul and Maria on that and how it integrates into the other subcommittees. I think it overlaps pretty well with what Ken and Lisa are thinking about, but that doesn't necessarily mean that's the only place we need to talk about that. There may be there may need to be, and certainly the funding I think is very complementary to what we're doing in some other areas, not for this group specifically, but yeah, I don't know, Paul or Maria, if y'all have thoughts about specifically what we heard about Alaska today and how we might run with that.
Well, it's a creative spin on what people are already doing in some respects. And certainly in Texas, we're doing a lot of that. That doesn't negate the new stuff that y'all are looking at and talking about. But has anybody sat down and figured out exactly what the profile of legal aid in Texas is? How many cases are handled for poor people? One of the ladies, Becca, suggested it was a 1/3, 1/3, 1/3 split. I'm not so sure that's accurate. In Texas, you've got 3 big LSC programs. The 3 of us close 70,000 cases a year. There's about 30 TGF funded smaller programs, and they close a certain percentage. And then there's pro bono projects. I'm going to find out what those numbers are because I think this group would be interested in knowing that.
That'd be really helpful.
So, I mean, whatever you're doing to come up with something new, I would presume you'd be concerned about, well, what's that going to add to the, you know, to the work here? It's that we're interested in it. I am, and Maria may want to add to that, but these are things that are, I mean, I can go back. I'm sure Maria could too. I can come up with a community worker program probably in 2 weeks. I've got people doing stuff that fit right into that. It's just a matter of calling it that. We've had, you know, a plan on the works for a couple of years now to do something with AmeriCorps. It's just a kind of an administrative nightmare to do all that stuff. You got to, I mean, when I started in legal aid, we had 1 grant. It was LSC, and then TGF came in, so it was 2. We have 40 grants now. So, you know, the administrative load on how you do this stuff gets pretty high after a while, but you have to consider back to what's the total effort that's being given and done. So, you know, if you can add something new to it that closes or serves another 5,000 clients, then it's worth doing. But this is something legal aid programs struggle with every day.
Right.
It's our bread and butter.
And my comment is, go ahead.
Go ahead, Maria, and then we'll go to the professor.
Okay. And I agree that some of the things that you're already thinking about, we already do. For example, we co-locate with some of the community partners that you're already talking about, and we do provide them with some guidance in terms of educating them on the law and things that they're seeing, issue spotting, and kind of letting them know, you know, we know you can't give legal advice, but here's general information, not advice, but information that you can share with our you know, common community that we're trying to support. So we're doing that already, you know, again, in a certain way. Now they can't actually give the advice, but if they are, if we have a co-located person at that community site, then that is very efficient to do, and that kind of thing. We don't have a lot of funding for that, but it is an efficient way to kind of make sure that it's efficient. You're meeting the one-stop kind of, you don't have to wait to make an appointment. There's an attorney right there. And able to provide and oversee some of the things that are going on that are information and or legal advice at the same time. So some of these projects are already kind of there, but not expanded because of challenges, some things that are going on. So yeah, but I agree. I think that it's definitely worthwhile to look at this and try to expand the use of folks. And again, a lot of us have added social workers to our programming. And so with that, they're certified and that kind of thing, so we can utilize them as well as another potential. And again, trying to keep those people engaged and providing services complementary to the legal services that we're providing is some of the things that are captured already, and that we can run with. I agree with Paul. If that's something that we could do it pretty soon.
And did you understand? I mean, one of the things that I was kind of heartened by, I guess, was I thought that 5.4 would have to be like changed no matter what. But from the presentations, it sounded like there was a way that you could work and implement some of these programs without having to mess with 5.4. Yes. I mean, like I've been out a while, but maybe it's a snap to change rules these days. But But the idea that you could maybe move forward and implement something without having to to, take on this big substantive,
How about amending solicitation? That's be a big help for legal aid programs. If you,
so I mean, some way that you could, I think you might get more traction in trying to, I think, you might get more traction in that UPL area and carving out things. I think you might get more buy-in, I guess, in that kind of an approach to help with expanding the assistance that you can provide, as opposed to having to have a rule change. But that's just, just from, I don't know if that's really right, but I'm just, from what I'm thinking, if there's a direction you can go in that would, have the minimal of having to mess with a bunch of rules, then that seems to me, and from what I heard, you don't absolutely have to do that.
Especially not if.
I mean, you might be able to take a leveled approach as to,
Isn't that what the waiver is?
It sounds like it. We need to
Well,
get
there's
more
some things
details.
that are required by waiver, but there's some things that they're doing that don't even require the waiver. At least in Alaska.
Right, Professor Fortney, and I think maybe Judge Spencer had a comment too. I couldn't quite see on the screen.
Sure,
Professor.
Justice. Well, sure, thank you. Well, and I appreciate the Justice's comments about the public input, because if you think about every presentation we heard, that was one theme that ran throughout them. And so I appreciate the different working groups, and that the game plan now may be to get that public input sometime down the pike. But I wonder if really that is what's going to inform the direction this goes in. And so from the outset, maybe we use the legal services connections that we have, some of the outreach that they already have, conduct focus groups, but do it at the beginning to really find out what the need is, as opposed to going down a particular track and then getting the public input.
Point. Judge Spencer, did you have something? I thought a comment came up on the screen, but I can't see it from here.
Oh, well, I just said it seems to me that court clerks could well speak to what they perceive as areas of need, and I'm quite certain they're providing legal advice. So could there
Right. I want you to mention that to the Chief Justice, Judge, because we've worked on in this group some guidance for court clerks actually on that very topic, so that they will feel more comfortable providing legal information and giving them some safe harbors, so it's not considered legal advice.
And I mean, some of the court clerks are so new that they don't know, they barely located the bathrooms. But others, especially I suspect longtime serving clerks in any area, and especially in rural areas, that they are actually handing out a lot of legal advice. But I think they could also speak to the numbers of people anywhere, that any court clerk could speak to the numbers of people who come in going, how do I probate my own will? My mother needs a guardian. Those are my areas of concern. But, can I show up at the state courthouse? I need to file a bankruptcy. I mean, all of those sorts of things. And I know the clerks are getting those questions.
Sure.
As are the law.
Absolutely.
Yeah.
Well, I think we can visit with OCA and with the foundation and be sure that we've got a good handle on all of those areas of need up front. I think that makes a lot of sense to proceed that way. So we can, I think the foundation, unfortunately, nobody with the foundation could be with us today, but I know that they routinely go through that assessment as part of their grant making process. So we'll be able to get that information in fairly short order, I'm confident.
One source of information about where the legal needs are, if you look at the Texas Legal Help through Texas Legal Services Center, and the questions that are posted, I mean, you can see the whole areas where guardianship, family law, landlord, tenant, or whatever, and they identify it real clearly, because none of those people have lawyers and they need advice. So that's almost an ongoing update as to where the needs are.
Do they record, not by individual IP address, but the number of times this form is downloaded or.
Yes,
or-
they have analytics on all their tech stuff, yeah. Particularly for Texas Law Help, and they have the older Texans, whatever it's called, hotline for older Texans. They have analytics on those as well, so yes.
We do, and we can get them pretty quickly.
Okay.
On Harriet's point around funding, I would just add, if our work gets to the point where it's not only the, should we and how we, but the actual cost of implementation, I think that would be really helpful just to know that, we come out with some actionable, steps, but also to pursue private funding. Sitting on, I have a couple of foundations that I sit on, and I would think that outside of federal or even what we might be able to do at the state level, we could get support privately.
Absolutely.
Cost of insurance is one of the items, for example, that I thought one of the subgroups ought to really delve into, because that could be limiting for certain organizations to be able to afford.
I can speak, well, I mean, we have some information about that kind of stuff because the State Bar of Texas provides malpractice insurance for a lot of the legal aid providers. So it's surprisingly low cost, and it just depends anyway. So I can provide that information. Don't need to give it to it today, but some of that information at least.
This may threaten to get outside of our scope, but it's related to what we've been discussing. This idea of trying to attract, say, tech leadership, or even, think about sort of these big tech companies probably have the resources to try to develop the types of platforms that we're talking about that can be used to facilitate people trying to get connected with legal resources. But our presenters were talking about potential profit motives that might entice these type of providers to engage. I know the state has ways of trying to entice companies to do things they would like to do, whether it's tax incentives or other kinds of incentives. And I just wonder if it's worth thinking about, to the extent, we know big tech has a presence in Texas. Just, in addition to sort of exploring foundations as a funding source, are there other ways to advise these entrepreneurial, innovative, non-lawyers who might have helpful ideas to come to the table, other than a sort of a strict profit motive from ultimately providing the services.
Actually, when we used to have the tech committee still in existence. So do they still hear pitches from providers? Because it used to be the case that people would come and pitch technology at a reduced cost for legal aid. I don't know if that's still occurring or not.
No, what they're doing right now is kind of piloting some tech innovations right now. So yeah.
But they are out there.
I also wonder if maybe, there may not be a direct sort of profit motive from delivering the legal services, but maybe by helping to create a tech-based platform, maybe they're developing a technology that they themselves could go use in another application. So I think about Starlink providing internet service in the Ukraine. They're providing, a service that they're not seeking, at least my understanding, they're not really seeking to profit on it directly, but they're also they're developing their technology and creating a network that they'll likely profit on in other applications.
Interesting.
There are some in the law schools across the country, and SMU is one of them. I don't know about the other schools in Texas. There's a program that they do a law tech, like a competition, and it's sponsored by Neota Logic is the company. And that's specifically designed to assist in the provision of providing legal aid or legal services to low income. So we had students do a variety of projects through our IP faculty sponsor. I didn't sponsor it, oh my gosh, but the IP faculty did. And there were some interesting things. So there is some of that going on, and it would be pretty easy for me to gather some of that if there's an interest in that. But I think that may be far afield. I mean, from a little far.
The real issue with the technology has always been in the services field is that things are developed and then they're not able to be sustained because there's no money. And so the reason why people are interested in enticing big tech companies is because there's a potential for sustainability. Because grant funding and things like that always run out, then you're sort of left with half of what was supposed to be done, and then you can't sustain it or update it or modify it or whatever. So I think that's one of the other things.
It's a drawback to it.
Yeah, but even, I mean, it's a tricky situation because even the Stanford Filing Fairness Project, the commission's involved with one of 6 other states. There are some challenges enticing tech because they need scalability, and that means that you've kind of got to go across state lines and state laws and things like that to make things work all across the United States. And but I think it just depends on what the innovation is, So
one of the things that we heard a little bit about today is Rocket Lawyer and LegalZoom are engaging in Arizona and in Utah to try to figure out ways to have basically tiers of information. So somebody can go to the website and fill out a certain amount online, and then the computer can decide, do you need to talk to a paraprofessional? Do you need to talk to a lawyer? What's the next step here? And they're actually employing lawyers to render some of that advice, which they can do more efficiently because they don't have to go out and look for the clients. The clients come to them through the system. And so, it is incentivized, at least that's the way that tech is being used there. I guess the question would be whether that then feeds into the 5.4 issue, or are there other ways to structure that where it does not? And I haven't thought enough about that yet, but that could be something that the subcommittees could look at.
Any other comments from the working group?
So are you assigning us to working groups? Are we volunteering for 1, 2, or 3? How's?
I already worked with you on one.
I think it'll be both. We would love for you to tell us where you're most interested in serving, and then we might request that you volunteer for a specific spot too, as we spread the love.
That's what we're calling it.
Yeah. Well, Justice Massengale, do you want to kind of lead briefly just where we think we're going from here?
Sure. So I guess this is the next steps on the agenda. And as was mentioned earlier in the day, the ultimate goal is to be responsive to the request of the Supreme Court and that we deliver our recommendations by the fall of this year. Just sort of working backwards at a very high level, that product is going to be delivered by the Access to Justice Commission. So our working group ultimately is going to create a product that will then be presented to the Access to Justice Commission. So we need to aim to have those deliverables kind of by early fall at the latest. So we're going to have a process that will put us in position to deliver that report at that time. In the nearer term, because we're going to do that, we'll need to work around the meetings of the commission. But in the nearer term,
Not necessarily. The commission may well meet around
Okay,
yours.
well.
So this is a number one project. So if the commission needs to meet, we'll meet.
Okay.
And we don't want you looking to us and saying, well, we can't do something until the commission meets, because we'll meet whenever we need to.
That's very helpful, and I appreciate you saying that. We did expect that we would have some interaction on the scheduling, but In the nearer term, we do know there are commission meetings on the calendar. And the way we've talked about this is that it would be helpful. We expect we're going to be expected to report our progress to the commission. The next meeting of the commission is in February. Obviously, we've had this meeting, and the next thing we'll be doing is sort of getting to sort of the place we are with the working group with each of the subcommittees. So making sure that we've got at least their initial membership identified, start getting people on the same page by pulling together materials for review, and start having our preliminary meetings. The next meeting of the commission after the February meeting is in late April. And
It's whenever we need one.
okay.
And to be real clear, we are not going to be scheduled around in a way that impedes the work of this group. And so let us know when you need meetings and we'll get them done. They may be abbreviated, very just targeted on this project. So we're not going through a whole page of reports that we have at our commission meetings, but we'll have a meeting to move this project whenever the working group needs us to.
All right, so with that, our thinking is that we'd like to probably get 2 meetings of our subcommittees before we reconvene this group, so that at that point in time, each of the co-chairs will be able to sort of give a nice report on the progress of the subcommittees, and also engage with the full working group on any sort of other separate progress that we need to make. So the discussion we've had among the co-chairs is that we hope to be in position to have had 2 subcommittee meetings and make a report back to this group by mid-April. And the thinking is probably a Zoom meeting for the next meeting. And did I miss anything, Lisa and Ken?
No, but I do want to emphasize something that Katie did mention earlier too, is part of the role of the National Center, and it goes to a lot of the conversation we've been having about public input and community stakeholders that are non-lawyer stakeholders, is we will be, as we're studying and reviewing, the National Center will also be conducting interviews and focus groups among all those stakeholders. And so that's going to be, as I see it, unless Katie wants to correct me, I think these might be parallel paths, right? And so that work is being done at the staff level as well. And we've already started identifying those groups and what kinds of questions we might ask and that kind of thing. So that's I still feel overwhelmed by everything today because I just heard like all this new stuff, but it is in the process, that part
Do
too.
you have a advice or sense, like, I'm kind of where you are in terms of the amount of information, but is there is it important to identify like which areas you think there will be, where either the need is or that works the best? Does that then drive whether the regulation is going to be entity regulated or community-based organizations? I mean, in the experience that you've had, is there like sort of a the step 1, step 2 kind of thing, that then drives the other thing and then determines whether, where we go from there? I mean, is that like the first thing that you get the information about where the need is and then go from there, or?
So I think it's really important, first of all, to understand the problem that you're trying to solve, right? So we've heard a lot about there's not enough resources to meet the needs for low-income Texans. And so as we've talked about for the weeks leading up to this meeting, and I think it's really become concrete at this meeting, is that I think we need a little more information. And so part of what we talked about as structuring the focus groups is really identifying the who are the people that we really need information from right now? Who are the groups, you know, and we're thinking legal aid providers, maybe community groups and nonprofits. You know, maybe some, like we could, thinking about people that could potentially be partners, not that they are going to be partners, but kind of hearing from them and their point of view. So part of the idea, and this has been incredibly educational for me to hear from you, along with our outside presenters as well. But part of what we're going to do is go to our list of stakeholders and start identifying who has the information that we need to kind of help structure where we're going. Because there's not a one size fits all. There's not really a manual on how to do this. And there's specific needs, particularly in Texas. And we really want to identify that. Mm-hmm. And we certainly wouldn't want to necessarily say everything that happened in Alaska, oh, that's great, let's just apply it to Texas, because they're very different communities. There are similarities, but there are also differences. And so what I will do as in the coming days is kind of think about, based on this conversation, I may make some recommendations to the leadership about, okay, these are some of the voices that I heard that we really need to prioritize. And then I have a colleague, Andy Workus, who has worked with Stacey Butler. He was on here for a little bit, but he had to jump off. But so we will start conducting those focus groups and interviews to help inform you of the path going forward, because I don't think we have all the answers right now. And so these are definitely concurrent steps that will be happening. But the most important thing to know is, first of all, if you have suggestions of like, you really need to like sit one-on-one with person X, please let us know. Or this group really could be helpful. Let us know, because the more thoughts and of different stakeholders we can talk to, we can't necessarily talk to everyone. Texas is a huge state, but we would really welcome that input. So then we're just making sure that, you know, we're not just talking to lawyers who are for it and who are against it, but we're really reaching out to the community to understand what those needs are, to then help you make an informed decision to come up with recommendations to drive change.
Well, on that point, one just occurs to me that we ought to really be thinking about faith-based organizations, because churches are becoming centers of first responders in a lot of ways for all kinds of crisis intervention. And so, and there are some really organized faith-based organizations in Austin, in Travis County, and probably in other places in Texas as well, particularly organized around social justice, and social services as well.
Disasters.
And sorry?
Disasters.
And disaster relief. That's exactly right. Anyway, so there's a pretty organized group of faith-based organizations, at least that I'm familiar with in this area. And so I want to call that out so that we don't overlook the faith-based community, because they're really if we don't do anything except ask for needs assessment kinds of questions to those groups, they'll be very easily able, I think, to identify the needs of the people that they work with in their communities.
You know, one other thing that I was thinking about is, the local area agency on aging, those are pretty much everywhere in the state. And they have, thanks to Bruce Bauer, who is wonderful, there's a statutory thing that allows them to give information to people and guide them on benefits. So, I'm also thinking, like, would we ever want to approach the legislature and ask them to expand their ability to do things? They've been doing it.
Yeah, they have a senior and a volunteer ombudsman program that provides advocacy on behalf of nursing home residents. And some of them are former or retired lawyers, in fact.
A lot of them are.
Another thing to think about too, as we're doing the outreach on this, and I had the working group co-chairs and I have discussed this, but I think it would be good to get everyone's input as we to have a sort of a unified sense of what we're trying to do to present to people, because I think, there's people hear about this and they think, oh, that's great, or oh, that's terrible, but they don't really have an idea of what it is what we've heard from the people today, for example, that we're actually looking at. And so I think there's a lack of information out there from some of the people that we want to reach out to for feedback. And in order to get the feedback we need to tell them what we're asking them, why we're asking them, and what we should provide. So I don't know what the best way for this group to come together around sort of an introductory document that we can share with people about, what it is that we're actually looking to do, so that then they can provide feedback about that. But I think that's
a good idea.
important early
And maybe
step,
some
because
talking
there
points.
are misconceptions out there about what we're looking at and what kind of information we need.
Well, and an agreed upon set of talking points about our work might just be helpful for each of us as we become ambassadors for this work.
Right.
Making sure that we're all on the same page about what we're saying we're doing might be helpful to each of us.
Yeah. Communication pieces.
Yeah.
And we've started internally with Katie and the leadership document like that. That's kind of the one pager that can be used for talking with non-lawyers, right? Like we're trying to simplify our messaging because yes, we have a lawyer group that's very interested in our work, but there's a lot of other community members and non-lawyer members that are also very interested in what we're doing. And so we've tried to, without us being plain language experts, we're trying to make it as plain language as we can.
And I would say there's, that's going to be really important, right? Because there could be interest at any point in time about this. And one of the other things we talked about as far as the role of the focus groups and interviews, I sort of talked about, okay, the first level, like who has information that we need. But as the work groups progress, we can continue doing focus groups. And if there's, if there are, attorney groups, it sounds like they're kind of interested. So, as your work begins to formulate, we of course want to get feedback from the attorneys in Texas about, what are their thoughts on the work that you're doing. And so we, at that point, will be able to use the focus groups as an opportunity to provide information to the lawyering community and to nonprofit communities and to legal services, and to get their feedback on something a little more concrete than we would be able to give at this stage in time. So we're really trying to be strategic. First of all, we wanted to be all encompassing in who we provide and try to figure out how we can, get enough out, figure out how to put our time in an efficient, effective way. But then first think about, okay, who has the information we need? And then once we start to formulate something, once, we start molding something, to really get feedback from people on that. And so that hopefully the process will be transparent and as open as possible. And we'll get some great feedback for you then to continue to make the informed decisions.
Any other comments? Austin ISD has canceled all extracurriculars and school tomorrow.
And so does Pflugerville.
Okay.
I was just going to say, I really appreciate the hybrid format, because from time to time, any one of us might not be able to be here in person and to be able to continue to participate, but not be physically in the room, whether or for some other reason, is helpful, I think. And so I appreciate the hybrid nature of the meeting.
And thanks very much again to the State Bar for the space and the technology and helping us do all this. Great. Appreciate it.
Thank you.
And the food.
And the food.
You know what, we'll probably be circling up in the next day or so about subcommittee formation. So if you do have a particular interest and want to shoot one of us subcommittee members like an email, like I'm really interested in what you're working on, Justice Massengale, I'd love to be on your committee. If y'all could do that, but maybe like Thursday, so that we can really start honing in on that list of.
Yeah, and anybody you feel strongly about beyond who's on the working group being involved, whether it just be an organization, an area, or a particular individual, having that input now, I think will be critically important to us in ensuring that when we bring information back to this working group as subcommittees, you all feel like it represents the voices and whatnot that it should.
Yeah. Okay, with that, I will adjourn us and we will be in touch about specific dates for next steps.
Thank you.
Thank you all so much.
Great.